Yeah, I'm trying to figure out how to work this thing. Yeah, I do. I could use a little help. Oh, join breakout room. Here we go. I see it. Sorry, here I come.
To you on the iPhone. What is your full name? I'm asking you to unmute yourself and state your name, please, and start your camera. No, it's not optional. You have to start the camera now. iPhone. Good morning to you, sir. Unmute yourself. What's your name, please?
Brian Little. Good morning.
All right, good morning to you. All right. Let's name a few more people. Thomas. Thomas there.
I'm sorry, Your Honor. What did you say?
Chalmers. I just let in the room. I'm trying to name that individual, find out who that is. You need to unmute yourself and start your video, please. And state your name.
Yes, it's Chalmers Locklear.
Locklear. All right, good morning to you, sir.
Good morning to you, sir.
All right. Garrison, Ebony Garrison. Ebony Garrison, unmute yourself, state your name.
Ebony Garrison.
Good morning to you, ma'am. How can we help you? I don't see you on the docket today.
They sent
Yes, sir.
me,
Yes, I do. Yes, I do. I'm sorry. Good morning to you. All right. And then Demetrius. Good morning to you.
Good morning.
What is your full name, sir?
Demetrius Lamar Green.
Good morning to you.
Good morning.
Hey, Mr. Brad, are we ready on your client, Mr. Gayton? Let's go back on the record with Mr. Antonio Javon Gayton. Mr. Bradfield, your client wants to take the deal. Is valid. His license is valid.
Yes, Your Honor. I did speak to Mr. Gayton, and he would like to enter a responsible plea for the speeding ticket. His recommendation is limited to access 6 to 10 over.
You want to take the deal, sir?
Yes, sir.
All right, stipulate to the face of the ticket as an accurate factual basis for that responsible plea on your client's behalf, Counselor.
We so stipulate, Your Honor.
Stipulate the probable cause for the dismissal of the other matter.
We so stipulate, Your Honor.
All right, I'm gonna find your client responsible for the amended count of 6 to 10 over. That is going to be $135. When can you pay it, sir?
I can pay it today or as soon as possible.
All right, make sure that it's paid by Friday. Pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload the DivDat app to your phone, or come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it, sir. If there's nothing further, I wish you the best of luck. Have a very good rest of your day, all right?
You too, sir. Thank you.
Thank you. This is the city of Detroit, Mr. Bradfield versus Marvin Lowe, the second, case number SP 1433447, counts 1 and counts 2. Appearance for the record, please.
Daphne Bradfield on behalf of Mr. Lowe. State your name for the record. Unmute your device and state your name for the record.
Marvin Lowe.
For purposes of arraignment, he stand mute and waive formal readings. Sir, are you the second?
Yes, ma'am. The second, sorry.
And we ask the warrants be recalled.
All right, enter a not guilty plea on your client's behalf. We're gonna give your client a $0 bond. I'm on Mr. Lowe. Do you have a valid driver's license, sir?
Yes, sir.
All right, I'm gonna put you in a breakout room with Ms. Bradfield. Ms. Bradfield's gonna get you an updated offer. Give me a second, Ms. Bradfield, to see if the license is valid.
Okay, thank you.
Join the room, sir, and wait on Ms. Bradfield, please. Let's pass the matter. Mr. Berry, are we ready on Lewis?
Ready,
James Lewis?
Ready,
Let's go
Your
back
Honor.
let's go back on the record with James Minor Lewis. I've given you an opportunity, sir, to speak to counsel. Counsel, what your client want to do?
As it turns out, Your Honor, my client has valid insurance. The court has confirmed he has a valid license. We seek dismissal.
Okay, I am going to dismiss the cases for providing valid documentation. If there's nothing further, Mr. Lewis, have a very good day and best of luck to you, all right?
Thank you, Your Honor. Thank you, Mr. Berry. Appreciate y'all.
All right, you're welcome. Have a very good day.
You too.
Mr. Berry, this is the city of Detroit versus Jamie Robin Lou Lyons. Unmute yourself, please. Case number, and good morning to you. Case numbers.
Good morning.
Case numbers, SP 1092339, counts 1 and counts 2. SP 1250422, counts 1 and counts 2. SP 1410277, counts 1, counts 2, and counts 3. SP 1424765, count 1 and count 3. SP 1456540, counts 1 and counts 2. SP 146863111. SP 1470061. SP 1505579, counts 1, 2, and 3. SP 1520324, counts 1, 2, and 3. SP 1533015. SP 1549618. 1. SP 1549620, counts 1 and counts 2. SP 1 and count 3. SP 155135111. SP 1553807, counts 2 and counts 3. SP 1553812. SP 1562724. SP 1636651, counts 1 and counts 2. SP 1705235, counts 1, 2, and 3. SP 1705240, counts 1 and counts 2. SP 1710898, counts 1 and counts 2. Appearance for the record, please.
Elwood S. Berry Jr., on behalf of the defendant. State your full name, Ms. Lyons.
Jamie Lyons.
Your Honor, for purposes of arraignment, we would waive the reading of the information and stand mute.
Not guilty plea on your client's behalf will give your client a $0 bond, which probably should be questionable. Ms. Lyons, you just you can't seem to get it together. At this young age, you've got all of these allegations. probably set yourself up for not getting a valid license for years. You understand that?
Yes.
All right, Mr. Berry, I'm gonna count up these, some allegations that I did not include into the record.
I counted 7 matters not included. There are more.
Hmm.
Look at the big frames on Mr. Berry. 7 matters not included. All right, you want to know that the allegations, Mr. Berry? I know
Yes.
you do.
Yes.
Expired plate, improper equipment, defective equipment, civil infractions, no insurance misdemeanor, driving while license suspended, repeat offender, driving while license revoked, and no insurance misdemeanor. Miss Lyons, Mr. Berry is going to try to help you with this. He's going to get you an updated offer. Keep in mind, if you don't like the offer, Miss Lyons, you have an absolute right to a trial, okay?
Mm-hmm.
Is that a yes or a no, ma'am?
Yeah.
All right, join the room, please.
You're under the third from the last.
I'm running it down again. Expired plate, improper equipment, defective equipment. I have 2 no insurances,
Okay.
1 driving while license revoked, and 1 driving while license suspended, repeat offender.
Thank you, Your Honor.
Okay, pass the matter. Miss Bradfield, for Mr. Lowe, his license is valid.
Thank you.
All right. All right, Mr. Boffman, are you there? I have a lawyer here for Graham, Charmaine Graham, that's trying to check in. Counselor, what about Graham? Okay, good morning on the iPhone. I just let you in the room. Good morning to you. What is your name, please?
Brian Little.
No, I've already talked to you, Mr. Little.
Okay.
iPhone, I just let you in the room. Unmute yourself, state your name, please. What's more? Unmute yourself. What is your name, sir?
Jaquisha Lloyd.
Is this Jaquisha Lloyd on the iPhone?
Yes, sir.
All right, I cannot, okay. Good morning to you.
Good morning.
I'm gonna put you in the breakout room number, I'm gonna put you, Miss Lloyd, in breakout room number 6. And your attorney, Mr. Bothman, is here, so give him a minute and he's gonna come see you, all right?
Yes, sir.
Join the room, please. Counselor, good morning to you on Charmaine Graham.
Yes, good morning, Your Honor.
All right, your other counsel was here. What are you working together with on this?
Yes, Your Honor. I'm from Mr. Jaffe's firm. I'm standing in for him. He had to go into a federal hearing.
Oh, that takes precedence over us, huh?
No, I wouldn't say so,
There's
Your Honor. That's
there's
why
an
I'm
answer.
here.
There you go. All right. Let's see. Miss Graham is here. I'm trying to pull up our file. City of Detroit versus Charmaine Graham, case number SP 158-13961. Appearance to the record, please.
Yes, good morning, Your Honor. Attorney Scott Colossus standing in for attorney of record Brent Jaffe, P84583, on behalf of Charmaine Graham, who is present via Zoom.
Okay, Ms. Graham, good morning to you. State your name for the record, please.
Charmaine Graham.
Today is the date and time set for a, help me out here. What is it set for? It looks like it must be set for a pretrial.
Your Honor, it was set for a bench trial today.
Was set for a bench trial today. I'm looking for Mrs. Graham. There we are. All right. Is there an attorney here? I mean, an officer here for Graham? Let's see. So Graham, Officer Melvin Brown or Robert Cully? Officer Melvin Brown or Robert Cully? Any response? I have all the officers in the main room that have appeared. I do not see that officer on my list. Go ahead, counsel.
Your Honor, given that today is the date and time set for bench trial, we are prepared to proceed. We would be asking for a dismissal.
I'm dismiss the case for no officer. Ms. Graham, if it's nothing further, you have a very good day and best of luck to you, all right? And thank you, counsel, for coming in.
Thank you.
Thank you, Your Honor.
All right. You're free to leave, Ms. Graham. Best of luck to you. Mr. Whitey, good morning to you.
Good morning, Judge.
Gates is here.
Okay. Now it's a question, do we have Officer Johnson Thompson or Officer Brown?
Let's see. I thought Ms. Gates was here. Yes, she's here. Let's see. Officer Melvin Brown is not here. I don't know if that's the same officer.
I think it's Jalen Brown.
And what other officer are we looking for?
The other one's a hyphenated last name. It's Johnson Thompson. First name starts with an L.
City of Detroit versus Raina Crystal Gates. Case number SP 163-6739, counts 1, 2, and 3. Appearance for the record, please.
Good morning, Your Honor. Dennis Whitey, P79560 on behalf of Raina Gates, who appears by way of Zoom.
Ms. Gates, good morning to you. Can you unmute yourself and state your name, please?
Raina Gates.
Good morning to you, ma'am. Today is the date and time set for a trial. Is there Officer L. Johnson Thompson?
Come here.
Officer Thompson, are you there? Officer J. Brown. All right. The date is the date and time set for a trial. I give the officer a half-hour grace period from the time the matter is set. That was at 9 o'clock. It is now 9:54. And hearing no response from the officer and not seeing any of those officers check in. Go ahead, Counselor.
Yes, Judge, because the officers have not appeared, today's the day and time set for trial. We would ask that this case be dismissed. We understand it would be without prejudice, and they could refile it if they choose to do so, but for today we'd ask for it to be dismissed.
All right, I'm going to grant that motion to dismiss Ms. Gates. That's a big one there. Best of luck to you. Have a very good rest of your day, all right?
Okay, thank you. Am I all done with dropping and everything?
I don't know if you're all done with driving, but I know you're all done with these cases.
No,
Judge,
no, I said
dropping. Bond condition.
Oh, bonds. Yeah, your case is over with now. The bonds.
Okay.
You're no longer have. I didn't even ask how she was doing on that, but I guess it's not of any consequence now. All right. Have a good day, ma'am, and best of luck to you. All right.
thank you. Have a blessed day.
You are. And be safe.
You too. Bye-bye. Thank you.
What's that last item that I made? Last item. What was that last iPhone that I called and renamed?
Jaquisha Lloyd, I believe, Your Honor.
Jaquisha Lloyd, right. Are you ready, Mr. Baughman?
Your Honor, would you please give me privileges? I would like to speak to Ms. Lloyd. These are matters set for trial, and if I can confirm, I don't believe that I've seen an officer.
Snap, Robertson, and Summers. Snap, Robertson, and Summers. I don't believe I've seen any of those officers appear.
Your Honor, would you just bring my client back into the main session? We're ready. And please and thank you.
City of Detroit versus Jaquisha Sade Lloyd. She's not coming in. I think you're gonna have to go get her, Mr.
Okay, I'll be right back. Thank you.
She's in 6.
I'm gonna get her information as well. So give me a few minutes, please.
Hello.
She's here, Mr.
Can
Bell.
you hear me?
I can hear you. Good morning to you.
Good morning.
Put some light on the subject, Miss Lloyd. I cannot see you.
Excuse me.
This is the city of Detroit versus Jaquisha Sade Lloyd, case number SP 1372544, counts 1 and counts 2, SP 137277571, SP 1561304, counts 1, 2, and 3, and 2173193991. There's also a SP 171036671. Appearance for the record, please.
Good morning, Your Honor. Harry Baughman on behalf of the defendant. Would you, ma'am, state your full name?
Jaquisha Sade Lloyd.
Your Honor, all of these matters, except for the last one mentioned, are set for a trial. I'm moving to dismiss those cases without prejudice for lack of a complaining witness. I believe the court was able to confirm that there's nobody here for those trials. As to the last matter, that matter is actually set for an arraignment, and we will waive any more formal readings, stand mute, and ask that that matter please be set for pretrial.
Well, I don't know why you just don't set the matter for trial. You
We can.
won all of these. Your
You're on a
batting
roll.
average is 1,000 right now.
We're on a roll. We can set for trial, please.
All right. Is there, again, I'll call it out on the record. Officer Summers, Officer Snap, Officer Robertson. I have hearing no response. I have all the officers in the main session that have appeared. I'm going to grant the motion to dismiss with stipulation of probable cause.
So stipulated.
I'm going to enter a not guilty plea on your client's behalf. Give her a $0 bond on the SP 171036718 case. And the trial date will be May 29th, 2025 at 9 a.m. All right, Ms. Lloyd?
Yes, sir.
All right, if there's nothing further, I wish you the best of luck. Have a very good rest of your day, okay? I'm going to waive the warrant fee. You're going to pay the reinstatement fee of $45. I only see one reinstatement fee, but you have another $45 on this assault case. All right?
Thank you.
Yes, sir. Do I pay?
Best of luck to you.
Ms.
Do I
Lloyd,
pay two
I'll be in touch.
reinstatement fees?
I'll call you. I'll let you know everything you need to do, okay?
Okay, thank you.
Thank you again,
All right.
Your Honor. Have a great day, everybody. Bye.
Yep, thank you.
I will.
All right. What's the gentleman's name that walked in? Good morning, counsel.
Good morning, Your Honor.
That's his client? All right. What's the gentleman's name? Sir, what's your name?
Charles Lewis.
Charles Lewis. All right, good morning to both of you, Mr. Lewis and Attorney Cross. Good morning, Your Honor. What are you gonna do with this case, Mr. Cross?
There was a motion up today and a trial tomorrow.
Anybody responded to your motion?
I believe they did. Mr. Bowman was on the case. He's no longer with the office.
All right. Get appointed counsel on, can we get appointed counsel on the spot for Jamie Lewis, please? This young lady. Let's see if we can get her a lawyer right now. So we don't matter. Ms. Lewis, I'm gonna see if we can get you a lawyer right now, okay? Me? Not you, Mr. Charles Lewis. Miss Lyons, I'm sorry. Miss Lyons.
I'm sorry to interrupt, Judge. I have a quick question. I'm not sure if my case was dismissed because I'm still not seeing my attorney, and my case was supposed to be at 8:20.
All right, you're in line, Mr. Give me the correct pronunciation. Ledoser?
Leducer, yes, sir.
Ledoser? Okay, you're in line. All
All right,
right.
thank you.
Thank you. Gildersleeve. Where's Gildersleeve?
Here, Your Honor.
Is that, good morning to you. What is Gildersleeve set for?
Today at 8:30.
At 8:30, so it should be set for the running on the bench warrant.
The ticket says for arraignment.
Why don't I see Gildersleeve, Mr. Berry? On the docket, I have a file.
8:35.
That's what it is. It's pre-trial. City of Detroit versus Kennedy Dwayne Gildersleeve, case number SP 168254431. Appearance for the record, please. Mr. Berry. What happened, Mr. Berry?
I can handle Mr. Gildersleeve, Your Honor.
He's here. He just drops off. He's here.
Okay.
Mr. Berry, appearance for the record,
Yes.
Mr. Gildersleeve, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gildersleeve.
Kennedy Dwayne Gildersleeve.
Morning to you, sir. Today is date and time set for a pre-trial. I'm gonna put you in a breakout room with Mr. Berry. He's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room, Mr. Gildersleeve.
Yes, sir.
Let's pass the matter. Let's go back on the record with Mr. Lowe. Mr. Lowe, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, there's a recommendation to dismiss his matters. We stipulate the probable cause for valid documentation.
All right, I'm going to dismiss the matter, sir, provide valid documentation. I'm going to waive the warrant fee. If there's nothing further, Mr. Lowe, have a very good day. Best of luck to you, okay?
Your Honor, I lost my privileges.
No, you haven't. You're set in room 2. Did we lose him? Yeah, now you did. All right. Join the room, please.
Thank you.
All right, Miss Bradfield. Let's go with Gouty.
I'm sorry, what's the name?
I think that's Gouty. G-O-U.
Yeah, I'm here.
Good morning to you. I don't see
Good morning.
missing on the
Oh, I see him. 8:35.
35.
Mm-hmm.
There we go. That's why when there's only one count, then
I know. It's like it's hidden.
that's good for Mr. Gouty, but this is the city of Detroit. Versus Malik Gouty, case number SP 168766901. Appearance for the record, please.
Daphne Bradfield on behalf of Mr. Gouty. Please state your name for the record, sir.
Malik Gouty.
All right, good morning to you. Today is the date and time set for a pre-trial. Mr. Gouty, this is one of those cases where it can't get any worse. It can only get better or stay the same. The offer is in the park after dark, it's gonna be a $240 fine and dismissal upon payment. You have an absolute right to a trial. I'm gonna let you speak to Ms. Bradfield, and you let us know what you want to do when you come out, all right?
Okay.
Joint pass the matter. Mr. Lewis, Charles Lewis, good morning to you.
Good morning, sir.
Do you have a valid insurance and registration?
I was test driving a car.
That's not the question. Let me ask you this. Do you have valid insurance and registration on any car that you own?
Yes.
Can I see that, please?
Let's see the guy that owned me. Get the registration there. I don't have the insurance certificate on me, it's in my car.
Can you get it?
The car's at home, I cut the bus down and my car broke down. But I got the registration, I got AAA insurance.
Ms. Snyder?
Good morning, Your Honor.
Step up, Mr. Lewis. This is the city of Detroit versus Charles Earl Lewis. Case numbers SP 1630146, counts 1 and counts 2. Ms. Snyder, can you put your appearance on the record, please?
Good morning, Your Honor. Alexa Schneider for the people, P80322.
Mr. Lewis, good morning to you. Can you state your name for the record, please?
Charles Lewis.
Very well. Today is the date and time set for a pretrial. I don't have an attorney yet. Madam Officer Thompson, can you give me the information that Mr. Lewis has as far as registration?
Yes, Your Honor.
Mr. Lewis is a walk-in, Ms. Snyder. He doesn't have the ability to connect to the internet. He indicates to the court that he's going to show the court valid registration.
May I approach, Your Honor?
You may. The tickets are for no insurance and no registration. He shows me registration that is expired too. Is this the 2010 Lincoln that you say that you were test driving that day?
No.
You were test driving a vehicle that says
A Chevy.
a Chevy?
Yes. I have the statement from the dealer.
Let's see what you have. Shows me a statement from Pristine Automotive. They have a card attached to the statement dated February 26, 2025. To whom it may concern, this letter is being written on behalf of our customer, Charles Lewis, who visited Pristine Automotive located on 8 Mile Road, City of Detroit, intent to purchase 2012 Chevy Cruz. During the sales process, Mr. Lewis requested to test drive the vehicle prior to finalizing purchase. While on the test drive, he was pulled over by law enforcement, issued a citation for operating on the vehicle. Immediately following the traffic stop, Mr. Lewis returned to the purchase of the vehicle. The car was registered and insured on the same day of citation. We respect that
for her on 3 days notice.
About that car.
Can do what? Can appear before 3 days
Took
notice.
that next time.
She did receive
I wonder
an
why
issue
this-
of various
I wonder
things
why
like
the
emergency
city
repairs,
doesn't
health and safety related repairs for a hearing.
Dealer.
Originally scheduled for 6/6 and inexplicably,
I was just going up to the
it
clock.
appears that hearing is
I don't know
moved
the
to
reason.
6:20.
Well, that's their
Any tenant
What do you
desiring
want
to
to
be
do with this,
relocated,
Miss,
is to.
Mr. Lewis says he does have
refund
insurance
of all
on
of their
his
escrow
own
funds,
vehicle.
all of their paid rent.
Now, you know this
from
registration that
9/17.
you provided me is not valid.
So that
right?
would affect, obviously, the
What's
escrow.
today?
order.
It's in May. It's,
And also the escrow.
on that Lincoln, is that
Prepare to
Lincoln the one
receive
that's
what?
down now?
Yes.
They're to receive.
What do you
a
wanna do,
refund of
Miss,
all of their rent paid from 9/17 if they paid rent.
Snyder.
From 9/17.
Your Honor, the sound went in and out a little bit, but basically from what I heard, you said that he has insurance, but does not have current registration and it's for a different vehicle. So I would ask if we could set it over either for trial or an adjourned pretrial for him to either bring in valid registration and insurance for any vehicle or some kind of showing of registration and insurance for that vehicle.
It also prohibits leasing and
Get are you gonna get this Lincoln on the road anytime soon?
I'm about to a Honda truck right now. I got AAA insurance on my Honda truck and I got the registration. That shit I bought from that dealer was for my niece.
Yeah, I got you. Well, in order to dismiss, I believe you, but I can't just dismiss, it'd have to come from a recommendation from the city attorney. And she would like to see proper documentation. If you can bring in some type of documentation either for that vehicle or your own vehicle, that's valid, then we'll dismiss the case. I know you come down, you're not able to join on Zoom, and you come up this way on the bus, but my hands are kind of tied on that, Mr. Lewis.
When can I bring it in?
Whenever you want.
I can go back and get it today.
And come back,
Yes,
and you'll be back before, how long will it take?
about an hour.
Well, come on. We'll pass the matter.
Okay.
All right. All right.
Thank you.
Let's pass the matter. Let's go back on the record with Mr. Gildersleeve. You need a trial as well, right, Mr. Gildersleeve? And the appointment of counsel, correct?
Yes.
We're gonna wait, like Miss Lyons is waiting to see who they send us for an attorney. Instead of setting a court date right now, trial date, let's get you a lawyer so they
It is for Mr.
All right, this case was scheduled today at 9 a.m. It is now 9:16 a.m. Deputy Lloyd, did you make an announcement for the defendant?
Yes, Your Honor, I did. He is not out there.
All right, and when the court called docket, the defendant was not in the courtroom, and the defendant still is not present in the courtroom. Defense, have you had contact with your client?
I did back about a couple of days back, but I haven't had any contact with him this morning.
All right. Court is going to issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. You're welcome.
Judge, I'm not getting any audio. I'm trying to figure this out. No, it's some.
Excuse me, at 7 o'clock Friday night. But I had to give him a credit card. But luckily the coordinator was taking the
And then they did start writing another. Skip this, go to you. I hate Power more. Oh, I hate the whole thing is video. That's what they're fighting. I'm pretty sure. It wouldn't surprise me.
Good morning.
My jury's still like once in the court. Are we gonna be able to?
All right, Cindy.
No.
Are you ready to go on record with their argument?
I'm gonna tape this down so it doesn't move on me.
Okay.
Does she have family violence in here? Or in the hallways?
I have no idea.
The French counsel was looking for him.
Okay.
I thought he was in the jury's waiting room.
All right, Cindy, are you ready?
Gonna have to do.
Okay.
Go ahead.
All right, the court is calling 2024 CR 2338B State versus Mariano Rendon. Can I have parties announce for the record?
Jason Garahan for the state.
Larry Blomquist for the defense. I'm here with my client, Mariano Rendon.
All right. So we're here on the charge conference and state it's the court's understanding that you are not going to ask for the law of parties.
That's correct, Your Honor.
All right, and defense. There are 2 points you wanted added to the charge, is that correct?
Yes, Your Honor.
All right, what are you requesting?
So I'm actually requesting a couple different things. So one, I'm asking that we continue to keep the law of both 9.31 and 9.32 in the charge. I believe that that's how we had it yesterday. I believe that's appropriate because in this particular case, the force used was a knee strike, and I believe that that is usually just force, although and the jury could believe or disbelieve that it caused serious bodily injury. There's testimony that other things can cause that. So, the jury could easily find that he used force and that no serious bodily injury was created. And so I believe that it's appropriate for the court to charge on both 9.31 self-defense, including force, and 9.32 self-defense, including deadly force. I think it's cleaner if the court
charges it both ways. In addition.
All right, just 1 second. Let's address that first issue.
Yes.
State.
So we have no objection regarding the 9.32 deadly force instruction. The state is objecting to the 9.31 non-deadly force instruction. And the defendant is not entitled to an instruction regarding non-deadly force because the victim sustained serious bodily injury in this case. We've had witnesses testify to that. And the cases that support that position are Farrell v. State. The site is 55 Southwest 3rd 586. Denman v. State, site 193 Southwest 3rd 129. And then Wood v. State, site 271 Southwest 3rd.
Like a lot of parties on going the opposite side. My client had a scratch on his neck and was assaulted during the commission of this melee. And so therefore, I think he's entitled to a self-defense instruction based on that.
All
We
right.
did have evidence of that assault by the photographs of the injury to his neck.
All right. And state with regards to the defense's request for self-defense.
So regarding it being in the charge, I guess I would just object to the application paragraph of it. I agree that it should be included in the defense of the third persons, but I would just reiterate that.
All right. Any final argument?
Yeah, I mean, I think the fact that he was actually injured during the assault, and he did testify about being assaulted by Esperanza Garza, who was assisting Pablo Rodriguez in the assault that occurred on the security officer. I believe that that's sufficient for us to get an application period on both.
All right. The court will allow the defense's request for self-defense in the charge. All right, is there anything else from either side with regards to the charge?
No, Your Honor.
No, Judge.
All right. How much time are you all requesting? We can go off the record.
I think about 40 minutes, Your Honor. It looks skeptical.
20 minutes,
Let's split the distance and call it 30 minutes. Your
19 minutes?
Honor. I'm obviously gambling with the house.
All right, so what I'll do is I'll give each side 20 minutes. If y'all end up going over a little bit, I won't interrupt you. Does anyone request a time announcement?
Fine.
Okay. There's another judge who would have given you all 5 minutes for closing argument. All right, everyone, because we're waiting for the charge, if you have someone who's on bond and you all have conferred and you're ready, you may approach. Hello, hi, who do you have? Oh, okay. All right, thank you. Okay. All right. Okay. All right, thank you.
Sorry.
No problem. Alex Russell Bacon. Alex Russell Bacon. David Warren Brown. David Warren Brown. Alexandra Hernandez Mejia. Alexandra Hernandez Mejia.
May I be excused to go to another court?
Yes.
That's mine.
Yeah, okay.
I'll come back and make sure.
All right, thank you. Bradley Tyler Galan.
Council's present, Your Honor. I believe Mr. Galan was allowed appearance on Zoom tag.
All right, and he hasn't, let me see if he's shown.
I don't know if we've provided him the Zoom.
Yeah, he's not here yet. If you'll let them know. Could I see the file on Arturo Villanueva? And State, are you ready to proceed on restitution on Villanueva? It's a failure to stop and render aid.
Let me see where.
Okay, sure. Oh, thank you. All right, so defense, Daniel Vela.
Judge, I'm here.
All right, have you had a chance to speak with the state on the restitution?
No, I have not, Your Honor. I would love to.
All right, state, Mr. Vela, I'm gonna put you in a waiting room. And if you can either call him or if you want to appear on Zoom to speak with Mr. Vela, it's concerning Arturo Villanueva.
Yes, Judge.
All right, I'll put you in the waiting room with, and your client in a waiting room, and the state will speak to you. Okay.
He called last week. He showed up. I guess they ran this morning and he showed up. So I didn't know. Previously scheduled. But okay, I just popped in and double check. Ma'am, it's like, okay. That's. This was the check. And I brought to the clerk's attention last week. The paperwork, but the count one. It's just count one. I combined the two paragraphs. Okay. But I told him the judicial admission in the plea is accurate. It reflects the chart. Just the plea agreement says one. Okay. It's just one. Okay. Thank you. Y'all need me just like. Yes, thank you. It was my right. Yeah, that's right.
Cindy, do you need IT called down?
I might. It's just,
Could you call IT down, please? Thank you.
Cindy, is it your audio from your equipment? It's my audio. Well. It's working now. I just shut everything down.
Oh, Norma, you can cancel it.
Cancel it. Yeah. I'm not touching anything, just gonna scoot back. You got it working.
So.
I don't wrap around the drivetrain because it's taking a photo.
Oh, yeah. Oh, you want me to just-
Here.
Jenna, could you ask Yaya to play out copies of the jury charge? Yes. And I'll need 6 copies. Okay. Thank you. Hello. Good morning. All right. Did you ask him to pull the file? Did you confer with the state?
Well, that's what I'm doing right now, but he has a response. It involves reaching out to witnesses.
All right.
So we.
Yes.
Brooks.
Which case is this?
Gregory Jennings.
All right, can I see the file on Gregory Jennings, please? All right, how are you doing? Oh, I'm doing okay. Thank you so much for dressing appropriately for court. So my understanding is the state has filed a dismissal in your case for insufficient evidence. So I'm going to sign it. Enjoy the rest of your day. All right, you're welcome.
Thank you, Judge. May we be excused?
Yes.
Oh, yeah.
Cheers. Oh, okay. Deputy Laura, all the jurors here? All right, thank you. All right, Zoe Brooks. All right, Yaya should be printing out the jury charge and then we'll start right up. All right, you need to make sure that you're on time for court, you understand? And no gum chewing. All right, so, State, were you able to attend an offer?
No, Judge, it's sort of a preliminary review. It's three different cases. It's
Okay.
all ag robberies, but they're all different ones.
Ah,
So we do need to get we've got a hold of one victim, just not the other two at this moment.
all right, so defense. State is currently in jury trial. Normally, I don't set this past 30 days, but do you have any objection to a 45-day reset?
Judge, I wouldn't object to 90 days.
All right, 44 days.
I heard the negotiations earlier. I'm gonna stop where I'm at.
Okay. Norma, if I can have a 45-day reset, please. 26. All right, is June 26th good for everyone?
I would say yes.
Yes.
All right, so we'll see you back here on June 26th at 9 a.m. All right, thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused. You're
Thank you,
welcome.
Judge.
You're welcome.
What day of the week is the 26th?
Thursday.
Here you go, Mick.
I conferred with Mr. Vela on Mr. Villanueva.
All right. And if only he were here now, he's not. All right, Mr. Villanueva,
Yes.
if you can call your attorney and tell him he's needed back in the Zoom.
Okay.
All right, thank you.
Will you pardon me for a moment, Judge?
Sure. All right, Alex Russell Bacon.
Here, Judge.
All right, if you'll come forward, please. All right, so you need to make sure you're on time for court, okay?
I'm trying to, throughout the last over here, for hard work that day.
All right, so court starts at 9 a.m., all right? All right, so we're gonna recall your case. And Norma, recall this case for, are you employed?
It's basically like last Monday.
Okay, so we're gonna recall this for Thursday, May 15th, okay? Once you sign the reset form, you're excused. All right, thank you. Norma, what case is that on? It doesn't tell me anything.
Oh, which one? That's the long. I mean, that's the bacon case. The email,
Yes,
that's the one with the bacon.
okay, all right, thank you.
The bacon case.
All right, who is here on Bradley Galvan?
Mr. Galan should be logged in onto.
All right, so we have Mr. Galan. You need to start your video. Thank you. All right, so we have a possession case and then we have a taken certain wildlife case. And the last time we were here with the wildlife case, there was some issue about an appellate ruling.
That's my understanding of the history of the case, Your Honor. However, Mr. Galan recently hired our firm this past week.
Mhm.
We just entered appearance on Friday.
Mhm.
So we haven't had the opportunity to receive, download, and review all the discovery completion. I did have a chance this morning to review the state's file
Mhm.
for the written discovery, but there is still some issues from the history of the case regarding that appellate issue. And I need to follow up with the state on some other discovery requests that were done prior to our entering the case.
All right, this has been going on for over a year now with us awaiting the appellate ruling. Ms. Ferguson,
Yes, sir.
they're gonna need a jury trial date, so if you'll confer with Ms. Ferguson on a jury trial date.
Yes, ma'am.
All right, and then once you have the date, let the court know.
Yes, Your Honor.
All right, thank you. All right, Mr. Galan, just give us a moment. Yes.
Judge, prior to setting it for a trial, just because I haven't had the chance to confer with the state about any sort of resolutions, we possibly have a plea deadline prior to.
All right, it'll be trial date and plea deadline date, and if you're all gonna enter a plea, it needs to be done before the jury trial date.
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
You're welcome. All right, and we're still awaiting the attorney. And I'm
Yes,
gonna go in, and I'm gonna go in the back right quick and check to see if the documents have been printed off.
I'll check.
Yes,
Yep,
thank you.
I'll check. Oh, July 22nd.
All right. So July 22nd is gonna be your jury trial date.
Yes, Your Honor.
All right, thank you.
And I'll make sure to get as much as I can.
All right.
Thank you.
All right, thank you. You're gonna need to be in court on July 22nd for your jury trial.
Yes,
All right, thank you for dressing appropriately for court.
yes, ma'am. Okay.
All right, you too.
understand.
All right, I cannot complain. It's a beautiful day.
Say about that, I mean,
Oh, oh, no. Hello, morning.
conferred. It made us.
Yes, to pull the file.
I'm sorry.
That's okay.
Yes.
All right, Jonathan De Hoyos, come forward. And counsel, you received all discovery?
We have received discovery on this matter, Your Honor.
And you said an offer has been tendered?
It has been relayed to us, Judge.
How old are you? All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date.
Judge,
You're welcome.
may we be excused?
Oh, you haven't got your date yet. All right, so we're gonna come back on June 10th. On June 10th, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date is jury trial date. You understand? All right, and thank you for dressing appropriately for court. Just have a seat and your attorney will bring you the reset form. Thank you. All right, so we're here on Arturo Villanueva.
Yes, Judge.
Oh, thank you so much.
Make sure it's a good phone number, because they're gonna call you on that one.
So have you all,
Okay, now this one's an email address, make sure this.
Agreement. Restitution?
We have not, Judge.
All right, are y'all ready to proceed?
We are not, Judge. The request that the complainant will make, I suspect, will require additional documentation.
The address you gave, 73191.
All right, defense, they're asking for 2 weeks
All right.
to provide documentation. Any objection?
Judge, my client would like to get this issue resolved. I mean, I'd like to go forward today.
All right, so Mr. Villanueva, what I can tell you is this is
Yes.
the last reset that the court is going to allow for restitution. State if you're not prepared with the restitution hearing at this next court date, then there's not going to be any restitution.
I understand.
Ms. Ferguson, I need a 2-week reset for a restitution hearing, and Mr. Villanueva, you can appear by Zoom.
Thank you, Your Honor.
I'm sorry, when? All right, so it's going to be May 27th. And Mr. Villanueva, I'll notate that there will be no more granting of state's requests for continuance as it relates to restitution, okay?
That's why it takes them a couple of days.
All right, thank you. Have a good day. Thank you for dressing appropriately for court. All right, you may be excused. And Bashan, that will be the last restitution we will have on that case. All right. We're on the record in 2024 CR 2338B State versus Mariano Rendon. Can I have parties announced for the record?
Megan Galloway and Jason Garrett for the state.
Larry Bloomquist for the defense, and I'm here with Mariano Rendon, the defendant.
All right, so the court received the final charge. Have both parties received the final charge, and is there any objection?
Judge, C objects to request the self-defense or the 9.31 instruction, but other than that, we're satisfied.
All right, are both parties ready to proceed with closing?
Defense ready, Your Honor.
All right, so each side you'll have 20 minutes. I'll give you a 5-minute warning. Is there any equipment that needs to be set up?
Yeah.
Yes. Sometimes it works, sometimes it doesn't.
Yeah, we're good to go.
Okay, awesome. All right, everyone, y'all need to make sure your cell phones are off. There's nothing worse when you're in your groove, you're doing your closing argument, and somebody's phones goes off. So let's not do that. We're ready.
All rise for the jury.
Everyone, please be seated. All right, ladies and gentlemen, thank you so much for your patience. As you can see, there are other people in the courtroom today. It's unrelated to this case. Each party is going to have a chance to do their closing arguments to you. I'm going to read you the jury charge, or what's called the charge of the court. You do not have to memorize it. You will have the original with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant Mariano Rendon stands charged by indictment with the offense of aggravated assault alleged to have been committed on or about the 20th day of August 2023 in Bexar County, Texas. To this charge, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the person intentionally, knowingly, or recklessly causes serious bodily injury to another. 2, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards the substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, justification defense of self-defense in defense of a third person. Self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, 1, who has a right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time deadly force is used, is not required to retreat before using deadly force. If all three of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. When a person believes, as viewed from his standpoint, that he is in danger of an unlawful attack or a threatened attack at the hands of more than one assailant, he has a right to defend himself as instructed herein against either or all of them. You are instructed that the defendant's belief that the deadly force was immediately necessary is presumed to be reasonable if the defendant, one, knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit the offense of robbery. Two, the defendant did not provoke the person against whom the force was used, or if he has, the actor abandoned the encounter. And three, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment as instructed in this charge. A person commits the offense of robbery if, in the course of committing theft of property and with intent to obtain or maintain control of the property, he intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of theft if he unlawfully appropriates property with the intent to deprive the owner of property. In the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or in the immediate flight, or after the attempt or commission of theft. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to effect the commission of the offense intended. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Defense of a third person. A person is justified in using deadly force against another to protect the third person if, one, under the circumstances as he reasonably believes them to be, the actor will be justified under the law of self-defense as instructed above and using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect. And two, the actor reasonably believes that his intervention is immediately necessary to protect the third person. The defendant is not required to prove self-defense, and the defendant is not required to prove defense of a third person. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person. 5, now if you unanimously find from the evidence beyond a reasonable doubt that on or about the 20th day of August 2023 in Bexar County, Texas, the defendant, Mariano D. Rendon did intentionally, knowingly, or recklessly cause serious bodily injury to Pablo Rodriguez Salazar by striking Pablo Rodriguez Salazar with Mariano D. Rendon's hand, or striking or pushing Pablo Rodriguez Salazar with Mario D. Rendon's knee, then you will next determine whether the defendant acted in self-defense or in defense of a third person and proceed to paragraph 6. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty and do not consider paragraph 6. 6. Now, keeping in mind the instructions regarding self-defense in defense of a third person given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the charged offense of aggravated assault, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, and whether the state has proven beyond a reasonable doubt that the defendant did not act in defense of third person. Self-defense application. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reasonably believed, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Mariano D. Rendon, and 2, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reasonably believed, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, and 3, Mariano D. Rendon's use of deadly force was not in response to verbal provocation alone, then you will find in favor of the defendant on his claim of self-defense and acquit the defendant, Mariano D. Rendon, and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault, and you further find from the evidence beyond a reasonable doubt that 1, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Mariano D. Rendon, or 2, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reasonably believed, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, or 3, Mariano D. Rendon's use of deadly force was in response to verbal provocation alone, then you will find against the defendant on his plea of self-defense, but next consider whether the defendant acted in defense of a third person as instructed below. Defense of a third person application. Keeping in mind these instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Anthony James Cochran, and 2, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that his use of deadly force and the degree of deadly force used were immediately necessary to protect Anthony James Cochran against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, and 3, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that his intervention was immediately necessary to protect Anthony James Cochran, and 4, Mariano D. Rendon's use of deadly force was not in response to verbal provocation alone, then you will find that the defendant, Mariano D. Rendon, acted in defense of a third person and acquit the defendant and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, and you further find from the evidence beyond a reasonable doubt that 1, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, as is not presumed to have reasonably believed that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Anthony James Cochran. Or two, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reasonably believed that his use of deadly force and the degree of deadly force used were immediately necessary to protect Anthony James Cochran against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force. Or three, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, that his intervention was immediately necessary to protect Anthony James Cochran. Or four, Mariano D. Rendon's use of deadly force was in response to verbal provocation alone. Then you will find against the defendant, Mariano D. Rendon, on his plea of defense of third person and find him guilty of the offense of aggravated assault as charged in the indictment. As you were instructed during trial to ensure that the jury, the court, and the parties are all receiving the same testimony, whenever a party or witness does not speak English, the services of an interpreter are employed. You are instructed that you, as the jury, are to base your deliberations on the questions as they came from the attorneys in the English language and in the responses from the witness as they came from the interpreter in the English language. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to reach a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous verdict, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty, nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Whatever it takes. This is the defendant's philosophy of how he runs Volcan and what he will do to somebody if he perceives them to be doing something that he doesn't agree with in his club. Ladies and gentlemen, you've heard all of the evidence in this case, and I'm going to talk to you about the elements of the offense. These elements have essentially been stipulated to by the defense, and really what we're going to be talking about is the justification and whether the defendant was justified in his actions or not. I submit to you that he was not. But regarding the elements of the offense, we have the offense date on or about August 20th of 2023. You heard multiple witnesses come in and say and testify to this date. You saw Officer Salas. He testified that he showed up to Volcan on that day. You heard from the witnesses who said that they were there at the club on that day. In Bexar County, you heard from multiple witnesses that this assault occurred at Volcan, which is located here in Bexar County on Ingram Road. Regarding the assault, intentionally, knowingly, or recklessly. And so you have the mental states and the definitions and the jury charge, and we'll talk about that further later. And then causing serious bodily injury to another. You all heard from Pablo Rodriguez Salazar. He took the stand and he testified about the injuries that he sustained, about the extensive hospital stint that he had to undergo. And you all also heard from Dr. Gunst, who testified to the serious bodily injury in this case. And at the conclusion of this case, we will be asking you to find the defendant guilty as charged of aggravated assault causing serious bodily injury. And we reserve the rest of the time.
All right, defense.
Ladies and gentlemen of the jury, first of all, I want to just thank you for your time and attention to this case. It's important to the state. It's definitely important to Mr. Rendon. You know, this is a terrible situation, and I'm sad that Pablo Rodriguez was injured in this incident, and Mariano is too. Unfortunately, Pablo Rodriguez and the people with him caused a dangerous situation to occur in El Balcán that night. They assaulted Anthony Cochran. They began this melee, which got out of control. Mr. Cochran is injured. You've seen the photographs of Mr. Cochran. This horrible thing happened because Pablo Rodriguez and the people with him drank too much and were angry and combative. I lost my clicker, forgot it. So this is my clicker. He's not doing a very good job. Okay. So we talk about it. So this case is really about a couple different things. It is about self-defense. It is about defense of a third person. And what's understanding and understand what we're here to do today is basically this occurs in just seconds. The assault occurs, and you heard from both Chris the Porter, you also heard from Mariano, that in just seconds, this, Anthony Cochran's asking for the beer. This tug of war comes in between the beer. Pablo Rodriguez grabs Anthony Cochran. They end up struggling. They end up going to the ground multiple times. And then all these people pile in. You heard Mariano's testimony, and you heard Chris saying, hey, I was trying to keep these people away. I'm 135 pounds. There's 3 or 4 of them. They're all on top of Anthony. There's nothing I could do. He was trying to help his friend. He just wasn't physically not able to because of the number of people that were involved. Mariano says when he gets over there, he starts pulling people off the pile. He's literally pulling off the pile. And he's very concerned and scared for Anthony because Anthony's in this pile of people. Mariano told you that they were punching him. They had already removed his baton. They'd already removed his radio. And now what's to stop them from removing that firearm? And he talked to you about how he saw that as danger. And you're going to see in the charge, there's the thing about apparent danger. That firearm is apparent danger. The fact that they are fighting with him and removing his uniform, and there is a weapon in that pile, that is a dangerous situation. And it's a situation that had that gone and had he gotten that firearm, horrible things could have happened. And because of that, and because of the totality of the circumstances, Mr. Rendon had to step in and defend Anthony Cochran. And he had to do that, and he had the reason to do that. But basically what the law says is that if Mr. Rendon was in Anthony Cochran's position and receiving that assault, could he defend himself? If the answer is yes, and if he has to, he would be justified under 9.32 is the statute to using deadly force to protect himself. So if he was sitting in Anthony Cochran's position, could he use deadly force to protect himself? If the actor reasonably believes his intervention is immediately necessary to protect the person. And obviously in this situation, he felt it was immediate necessary. Why? Because when he gets up there, Anthony's surrounded by these people. They're punching him. They're on top of him. They're taking off his items, and he's got his firearm there. So it's clearly immediately necessary for him to step in and do something. And if you watch the video, and we'll talk about the video being edited a little bit later, in that video, you see, as you watch it, you see Pablo Rodriguez fighting to get back to his stomach so he can get back up. And so this is clearly a dangerous situation, and Anthony Cochran has his hands and is holding Pablo Rodriguez, but Pablo Rodriguez is holding him as well. So it's obviously reasonably necessary. We talk a little bit about it. We kind of talked about this. Pablo Rodriguez is doing 2 things during this assault. Okay, one, he's creating this incredibly dangerous situation where he's physically assaulting him, causing him, Anthony Cochran, bodily injury, but he's also causing, and again, when we have multiple attackers, like in this case, where we have multiple people attacking him, that danger level goes way up. And then also we have the danger, and then there's also this robbery that's occurring. And you heard Chris, the porter, talking about how he saw Pablo Rodriguez tugging on the radio of Anthony Cochran and stripped it off of him. And we know that eventually it's stolen and transported to another location. And that is a robbery, literally a robbery. It is a theft from person using violence, and that is a robbery. And there's a deadly force in, when we talk about now look, I don't think it was Mariano Rendon's intention to use deadly force. I think he was trying to do what he felt that he needed to do to stop this man from fighting, possibly getting to his feet or getting the gun of Anthony Cochran. Okay. I don't think in his mind he's thinking, I'm going to use deadly force. But deadly force, understand, is it's a result of the offense thing. So, for example, if I punch somebody, that's not normally deadly force. But if I punch somebody and they're next to a stairway and they take a bad step and they fall down the stairway and they receive serious bodily injury, then that is deadly force, even though it's the actual intent is just to throw a punch. It's more of like the consequence of what happened. And that's why we're talking about that, is just because there's this allegation of serious bodily injury. So if the court, when we talk about this presumption, so there's a presumption in the law that says that if you believe that a couple things happen, if you believe, first of all, that Mariano Rendon did not create the difficulty and provoke the difficulty, he did not, absolutely. Pablo Rodriguez created the difficulty. Mariano Rendon was just responding to it. Second, that he's not doing any kind of crime other than like a traffic offense. And the reason they have that is because they don't want drug dealers basically saying, oh, he came to rob me for my drugs and I'm now defending myself. No, and at this time, what is Mariano Rendon doing? He's in his bar doing the bottle collection. He's not violating the law. And then third, that he is aware that they're and trying to prevent a theft, or I mean a robbery. And a robbery is that violent taking of the radio and by person. And obviously he is doing that. So the state would have to disprove beyond a reasonable doubt that that did not occur. And they're not able to do that because we know that that occurred from the testimony that occurred. So what do we have? So we have this presumption, and that means that you have to find, if you believe those three things, if you believe that Mariano Rendon was aware of the theft that was occurring and trying to prevent it, or the robbery that occurred and was trying to prevent it, and you believe he was not provoking the dispute and he was not committing any crime when he did that, then he is you have to presume that his use of in this case deadly force was reasonable and necessary. You have to presume that. You were required to find that if you find those three things. And I would tell you that you have to find those three things because that's what the evidence in this case indicates. So, and this is the robbery presumption that we've been talking about. And you see in this case, it's that you have to find that because of those three elements. So look, when you read the deadly force provision, it talks about three different things. One is, did the person intend or know that what they were doing would cause serious bodily injury? And I would tell you, no, I don't think he knew that. I think that he felt that that was the easiest way for him to get to comply. I think that he felt that the knee strike to the abdomen was reasonable and necessary to, one, stop Pablo Rodriguez's continuing fighting with Anthony Cochran, was reasonable and necessary to prevent Pablo Rodriguez to get the firearm of Anthony Cochran during that struggle. I think he felt that was reasonable. And I think that he felt that that was going to cause, some kind of pain and also maybe disrupt him enough that Anthony Cochran could get a hold of him. I think also one of the things to remember is that this happens in just seconds. And remember the chaos of this scene that happens. Remember when we watched the video and I pointed out there's a guy in the back of the video that's on the ground who was probably one of the people that was attacking Anthony Cochran. And there's a security or some kind of staff member between him and there. You can kind of see if you go watch the video and if you pause it, you'll see him sitting there or on either on his butt or on his knees. That person is still a threat to Mariano Rendon. We also have Esperanza, who's running around pulling at him and scratching his neck and assaulting him. And that gives him concern for his own safety because he's in a situation where he has Pablo Rodriguez, these other three guys that are attacking, and Esperanza, all attacking Anthony, but also attacking him. And he has injuries that indicates that. That's why it's not just defense of a third party, it's also self-defense, because in the totality of the circumstances, he is also under attack. as well as the young man that got his shoulder dislocated. This is a melee and everyone is in danger while this melee is going on. We see people all the time, Muay Thai fighters using knee strikes to the abdomen. We see this in all kinds of martial arts. And 99% of the time, nothing happens. 99% of the time, I mean, there may be some thing, but we don't have serious bodily injury. We see police officers do this all the time. I'm sure if you've watched Cops or any of those shows, you've seen police officers use knee strikes on the abdomen of people. They wouldn't do that if it was going to routinely cause serious bodily injury, okay? But like we talked about with the punch, I could throw a punch at somebody, not intending to cause death or serious bodily injury, but I could throw that punch at them and they could fall down and hit their head on this table, or they could fall down a flight of stairs, or all kinds of things can happen that transforms it from just like force to deadly force, okay? But the question for you is, when you're looking at the reasonableness, because I think you do have to look at the reasonableness of what he did. Was the knee strike reasonable? Another thing, when you watch that video, take a look at it. Right before he actually drops his knee, you'll see him crouch down a little bit. So he's not dropping from his full height. He actually crouches down a little bit before he goes down. And I think that's important. But again, seeing police officers, seeing Muay Thai fighters, seeing all these people, just like you all have, do these kind of things without having that kind of a result. Let's talk about the injury. I think there's a real legitimate issue in this case about the injury. Was it caused by the knee strike? And again, if you find it was not, then there's no serious bodily injury, then Mr. Rendon is not guilty. And so you'll remember when I was talking with the doctor and we were talking about all these different things that can cause a ruptured intestine. We talked about an infection that causes inflammation or diverticulitis. We talked about peptic ulcers. We talked about blunt force trauma is one of the things that can do it. Penetrating trauma, like a stab wound, is something that could do it. Inflammatory bowel, appendicitis. There's just long-term NSAIDs, bowel obstruction, and one of them is scarring from surgery. And we know from the medical testimony that Pablo Rodriguez had a previous hernia operation. You heard the doctor talk about that, and he talked about how sometimes there can be scar tissue inside the bowel that can, over time, cause a bowel obstruction. So one of the things you need to do is you need to sit down and take a look at that and decide if this knee strike actually did cause that serious bodily injury. One of the things is there's a delay in reporting. Is you saw him walk out of the bar, you know that he went home, and these problems developed later. Is it because they did not occur from the knee strike, or is it because there was just a delayed outset? So you need to sit down and take a look at it. And again, I think that fact that he had this previous hernia surgery and that scarring from a surgery is something that can cause a bowel obstruction, I think is important. We also look at this, is if it's possible that the knee strike caused it, that's not proof beyond a reasonable doubt. The state's burden is very high. We talked about it. They have to prove beyond a reasonable doubt that the knee strike caused that injury. Most likely is not beyond a reasonable doubt. You have to believe beyond a reasonable doubt that the knee strike is what caused the injury. One of the problems with the state's case is we have unreliable witnesses that are basically telling you lies. This is one of the most significant pictures in this case, not because it goes to any element of the offense, but because you heard the testimony of Tina Jimenez and Pablo Rodriguez, that he just walked out of his own accord. He just got up and walked out. But here we see him being escorted out by Anthony Cochran. Okay. Was it that he was so intoxicated that he doesn't remember being escorted out? In which case he probably lied to you about the number of drinks that he had. Or is it that he's purposely trying to make himself look good and reasonable and in a sense lying to you? Because we know that he got walked out. So it's like somebody brings something and then we bring the receipts. And that's the receipt of that. This tells you that when he told you that and when she told you that that was not true.
5 minutes.
Next slide. The same thing with the drinking. We have the same issue. So first of all, let's talk about court and police math when it comes to drinking. Every person that's ever been convicted of DWI, 90% of them told you they had 2 beers, and that you can't get to 0.08 on 2 beers. It's a.
All right, that'll be overruled.
So every person says they had 2 beers. In this case, he told you he had 5. And so the actual, this is just my joke equation, but it's kind of accurate. Is you take the number of actual drinks you had, you divide that by 3, and that's what you tell the police officer. So I had 6 drinks, I tell the police officer I had 2. If I had 5 drinks, I divide that by 3, and I tell them that it was actually 15, but I tell them it's 5. But the bottom line is you're saying something to sound better than the truth, which is a lie. We talk about all the things, Tina and Pablo both made it seem like you barely had anything to drink. But then when we bring the receipts, we see Officer Casey Wilson said that when he saw them, that they were highly intoxicated and combative. And Pablo, her own statement, she once she heard the tape, because we brought the receipts, she admitted he drank and drank and drank for his birthday. He was a little more drunk than normal. He had too much to drink. But the bottom line is she only admitted to those facts when she knew we had it on tape. That is somebody who's lying to you. That's somebody who's telling you something that's not true. And the video, let's talk about the video real quick. Why is this an edited video? Obviously, we know that the encounter lasted a long time before this occurred. When you see something like this and you start to turn your video on, you hit the play button and you're bringing it up and it's blurry at the beginning because it takes you a second to get oriented when you're not expected to this. I don't believe Esperanza 1 minute that she got this from the internet. Somebody she knew in the bar took this video and gave it to her. And they took the part that was bad for them and they cut it out. And that's why we only see the last few minutes of this fight. The problem is once you have people that are lying to you, you don't know when their lies stop. You don't know when they're not telling you. Once they start telling you lies, you don't know where that stops. And you heard one party that was being honest and truthful in this. But we have 2 different versions of this event, 2 totally different versions. You have the version of them. He took 1 extra drink and he threw it in the trash can. And Anthony Cochran, who is sober, just goes berserk and attacks him. Is that reasonable? That's not reasonable. He's a security guard. He just wants to get the beer in the bucket so that he can go home in an hour or less than an hour, in about 45 minutes. This is going to keep him there a lot longer than that. It's not reasonable. What's more reasonable is a drunk person who paid for a beer, who doesn't want to give it up and is willing to fight for it, feels insulted. When we talk about that, we talk about the 2 different versions, totally different versions. We have one group of people that have told you things that we know are lies and have misrepresented things to you, and we have another party that has not. So you have to choose to believe. And I would tell you that this man and Chris the Porter never lied to you. But when they brought their stuff up and we brought the receipts, they failed. This was a terrible police investigation. And that's important because it's hard for you to get the right facts. How long, we talked about it, it takes 3 seconds to identify these witnesses. What's your name? What's your address? Failed to do it. This is a felony case. This man might go to prison for 20 years and they can't take 2 seconds to take the names and addresses of these witnesses and identify them. Witness statements. Every single person that saw that fight should be getting a witness statement, even if it's only a few minutes on the body cam. There's people that never spoke to the police. They didn't even identify them. And what were they doing? They were lying about their names. You heard Esperanza say that she's an admitted liar. She said I gave him a fake name. We have the other guy. His name in the report is completely different than what his real name is. They failed to go look at the videos. They're right there. The only reason they have the videos from inside the club is because we provided it to them. They never asked Tina and Pablo who else was there. Why wouldn't you do that? Hey, you've come to us, you want us to investigate this, then we're going to sit down. Who was this other person? Let's go get a witness statement from him. They never talked to any of them about the assault. They never confronted. If you're taking a witness statement from somebody, you take what they got to say, but then you take what the other people say and say, hey, wait, they're saying that you assaulted somebody. Let's ask about that. They never did that. It was a biased, not only was it a terrible investigation, it was a biased investigation. There were crimes that they knew about. They knew about the robbery. They knew about the assault and they never looked into it. They never confronted those people with that. They never confronted Esperanza about her conduct on the video. Look, if she really got the video from some strange person, the state can file a subpoena, get those social media records, find out when that video was transferred and who transferred it for them, and go see if they have the original video that's unedited.
Time.
Failed to do that. Just 1 second, Your Honor.
Okay.
Next slide. Look, they have to prove this case beyond a reasonable doubt. And they have failed to do so because they have failed to disprove that he was not acting in defense of himself, not acting in self-defense of Pablo Rodriguez. And because they did the robbery, you're presumed to find that that is accurate. Thank you very much for your time.
All right, state. Yes.
I don't care how bad Pablo is, he's a civilian. Ladies and gentlemen, that is unreasonable. And it is not supported by the law, and that is the reason that we are here today. Now, I've already talked to you about the elements of the offense. I'm going to talk to you about the mental state. You are not required to read minds. You can infer this from the facts and circumstances that surround this. You heard testimony from the defendant that he did not bluntly strike Pablo with his knee because he intended to be cruel. But his acts, by definition, were reckless. And we're going to look at the facts and circumstances that surround this and prove that it was reckless. The defendant's desire was to strike Pablo with blunt force with his knee. If you look at State's Exhibit number 2, when Pablo is struck, he is laying, his head to his tailbone is laying flat on that wood dance floor. His left side of his stomach is fully exposed, and the defendant grabs Pablo's left knee and grabs onto Anthony Cochran's back and drops his knee down. We all know that the stomach is a sensitive area that is full of many vital organs, and any blunt force to an area like that that's unprotected can cause a tear, rupture, or fracture of any bodily organ. Now, I want to talk to you all about the defenses. The defendant was not acting in self-defense at all, okay, especially against Pablo. There's been no evidence that he perceived any threat coming from Pablo. What he testified to is that he believed that Esperanza was using force against him and that he used force back against her. But regarding Pablo, you all see the video. The video is the clearest piece of evidence that we have in this case. And Pablo is not threatening the defendant. Now I want to talk to you all about defense of third person. Regarding the defenses that are in the jury charge, just because you receive them in the charge does not mean that it's the court commenting on whether these are legitimate defenses or not. Okay, the defendant is entitled to it because it was raised by the evidence. And so let's talk about defense of a third person. A defendant is justified only when he reasonably believed, as viewed from his standpoint, that Pablo was using or attempting to use unlawful deadly force against Anthony Cochran, that his intervention was immediately necessary to protect Anthony Cochran, and that his use of deadly force and the degree of deadly force were immediately necessary to protect Anthony Cochran. Well, let's look at the evidence. It is clear that Pablo Rodriguez Salazar was not using or attempting to use any unlawful deadly force against Anthony Cochran. And how do we know that? Well, the witnesses all testified that Pablo didn't use any force at all. When you look at the State's Exhibit number 2, when Pablo's laying on the ground, you can see that he's kicking his feet around a little to free himself from the grip of Anthony Cochran. That is not deadly force. That at a minimum would be non-deadly force. And so you cannot respond to that with deadly force. The defense witnesses testified to a tug of war over beer. Okay, that is non-deadly force. You cannot respond against you can respond against unlawful force with regular force. You cannot respond against unlawful force with deadly force, which is sending somebody to the hospital for 50 days. The defendant's intervention was not immediately necessary. And how do we know this? In the state's exhibit number 2, Anthony Cochran is on top of Pablo the entire time. Pablo, at a minimum, is shifting his weight from side to side. As I explained earlier, Pablo's head to his tailbone is laying flat, stomach fully exposed, and that's when the defendant grabs onto Anthony's back and Pablo's leg and drops his knee down. So he knew at that time, in his standpoint, he knew that Anthony Cochran was on top of Pablo, and he knew that Anthony Cochran had control of Pablo at that time. That's what makes his acts unreasonable. His use of deadly force and the degree was unnecessary. The defendant testified that his own staff is not allowed to go hands-on with patrons. That's a rule that he implemented, and he violated himself. You heard his testimony. He's not a peace officer. He's not a security guard. So if he has this rule in place for his staff, why is he violating his own rule? He testified, the defendant testified from that stand that the proper next step would have been to go and grab Pablo's legs and neutralize any movement. Okay, that is not what he did. A reasonable belief is a belief that is held by an ordinary and prudent person in the same circumstances. So let's look at that. Let's look at all the other patrons that are in the vicinity of what is going on. They're all standing watching there, including Cruz, who I would implore was not a credible witness at all. He wouldn't even admit that he was in the state's exhibit number 2 and a photo of him clearly in the entrance exit way of Volcan. You cannot believe anything that he said. You can see that other people, other patrons are walking by. Some people are still dancing. And some people in the crowd are yelling at the defendant. And look at the defendant's demeanor in state's exhibit number 2. He's yelling at people in the crowd that are not even involved. There was no apparent danger, and that is clear because there is no sense of urgency from anyone else in the location but the defendant that's sitting over there. The defendant is the only person who felt that he needed to protect Anthony by assaulting Pablo. If Anthony had a firearm, why does he need to be protected? That was an unreasonable belief. There's no presumption of reasonableness in this case because there's no evidence of a committed robbery. Ladies and gentlemen, you will have the evidence with you, which includes video of Esperanza, Carlos, and Ricardo exiting the location. You don't see the hat, you don't see the baton, and you don't see the radio anywhere. The defense also, the photo that he had with Pablo walking out, you don't see the radio, baton, or hat anywhere. Volcan was packed that night. Anybody could have taken those items. There is no proof that Pablo, Tina, Esperanza, Carlos, or Ricardo took any of those items. And so there was not a robbery on that day. Furthermore, at the time that this occurred, the defendant had no knowledge that these items were missing. He comes in when he says that this whole, using their words, melee is going on. He has no idea that those things are even missing if they were, and they are depicted in the state's exhibit number 2 laying on the ground. But you all need to track the exit of the witnesses, and you can see that they are not in possession of any of those items. You can also look on the officer's body-worn camera. When they're speaking to the officer, they are not in possession of any of those items. And so we have proved beyond a reasonable doubt that no robbery occurred. The evidence supports a finding against the defendant's assertion of self-defense and defense of a third person. Testimony is evidence. We talked about this in jury selection, so we're going to talk about some of the testimony that occurred. You heard from Officer Salas. He testified that he was first on scene at Volcan on August 20th, 2023. He testified that Pablo did make an outcry to him on that night regarding the assault, but he did not make any arrest on that night. when he had an opportunity to view State's Exhibit number 2, he testified that he would have reached a different conclusion had he been in possession of that video on the night. We'll move on to Officer Soto. He testified that he was dispatched to Pablo's home 2 days later on the 22nd to take a report. He took statements from Pablo and Tina. He researched the negligent investigation that Officer Salas did. And knowing that information, he still decided to write up a report and forward it to a follow-up unit for investigation to occur, because he determined that an offense had occurred. Detective Gross testified that he conducted many interviews. He collected the video evidence, which corroborated what the witnesses testified to, Pablo, Esperanza, Tina, and Carlos. And the result of his investigation was the use of force was unreasonable. He also conducted an interview with the defendant, who stated that he didn't even touch Pablo at all, and that the internet was down for the cameras, so he was unsure if he would be able to provide the surveillance video. Ladies and gentlemen, if the defendant was in such fear and he felt that his acts were reasonable, why would he say that he didn't touch Pablo at all? Because he knows that his use of deadly force exceeded the scope of the law. Of important note, he fails to mention things that he testified to on the stand, which was that Pablo jolted his head. The first time that we heard of that was last week. That he was in fear for Anthony's life. He's never stated that until last week. That Pablo was reaching for a gun. That has never been uttered until last week when he was on that stand. And that Pablo was cut off from receiving any more alcohol. Never mentioned that to Detective Gross. I want to agree with one thing that the defendant said, is that it's easy to Monday morning quarterback when you know that you're facing the jury of your peers and you've had 2 years to concoct a version that is sympathetic to yourself. The only thing that the defendant told Detective Gross is regarding Esperanza. And he said that Esperanza attacked him and that he used force against her, okay? What is important is that nobody had State's Exhibit number 2 at this point. And so the only reason that he's coming up in here and taking accountability is because we have State's Exhibit number 2. If there wasn't a patron that was reporting that night, we would have never known who caused serious bodily injury to Pablo. Tina would have never known that this person that she trusted caused serious bodily injury to her husband. You all heard from Dr. Guns. He testified that Pablo sustained serious bodily injury. You heard that Pablo had to have 2 surgeries. The first was removal of a part of his intestine, and the second was the bowel obstruction that was caused by the first surgery. Okay, not some hernia surgery that happened 9 years ago. And so I want you all to think, is it possible that the hernia surgery is what caused the intestine issue? Maybe, but what does the evidence suggest? Look at the location of the blunt force strike and the temporal location. 2 days later is when he has to go to the hospital. It's unreasonable to believe that he lived with the hernia surgery 9 years, and then just shortly after this is when he's gonna have issues from a hernia surgery. That's unreasonable. Pablo, Tina, Esperanza, and Carlos are all consistent with each other and the video evidence. At this time, you are solely determining whether the defendant is guilty or not guilty. Not defenses to this offense, or that the defendant did provide some video that's hazy and we can't even see what's going on, that Pablo was cut off if he was intoxicated, that it was last call, and that Pablo didn't throw his beer away. I want you all to think, what was the rush? The defendant testified that his patrons can continue drinking until 2:15. What was the rush that Pablo had to throw his beer away right then and there? that it would cause Anthony Cochran to grab the beer from Pablo
5
and
minutes.
throw him to the ground. We do have the burden beyond a reasonable doubt. It is not beyond all doubt, but ladies and gentlemen, that video tells you everything that you need to know. You are not to let bias, prejudice, or sympathy play into any part of your deliberations, and you all do have a duty to deliberate, to consult with each other, and with a view towards reaching a unanimous verdict. And you shouldn't hesitate to re-examine your views and change your opinion if they are unreasonable. You all swore to render a true verdict according to the law and the evidence. Ladies and gentlemen, there is only one verdict in this case, and that is finding the defendant guilty of aggravated assault causing serious bodily injury. We cannot hold a substandard law enforcement investigation against Pablo, okay? Tina had to fight for Pablo to receive an investigation that would bring us here today. You need to hear them, let them know that you hear them, that you believe them, and find him guilty. Thank you.
All right. All right, is there anyone who's ready to proceed? Just have the clerk pull your file and I'll take your matter up.
Judge?
Yes,
Can I approach?
yes.
Apparently, my client showed up.
Okay, and who's your client?
Ms. Hernandez Mejia, please stand up for the court.
All righty, all right.
Thank you, Judge.
You're welcome. David Warren Brown. Could I see the file on David Warren Brown, please?
I think there was only one that wasn't admitted. Right? Well, no. These reports,
Okay, as soon as you come out, let me know, and then I'll put them up.
I think it's two. Well, no, it's three, because it's state exhibit number 22.
Victoria, that has helped greatly.
Francis gave it to me.
Oh, yeah, I'm like, wow. So, yeah, thank you very much.
Yeah.
And you know what, I smell it, even though I have to open it, I still get the scent.
Well, 22 is not in here.
Oh, it is awesome.
Yeah, because he didn't.
And I'll make sure you get it back.
Yeah, that one's not there.
All right, thank you.
I smelled it on the third floor,
Oh, so none of these
Thank
came.
you.
but I didn't smell it in here, but I did smell it on the third.
See, I'm like Gus from Psych. I can smell it.
Yes, and it is.
Oh, yeah. That's number one. I keep thinking that's a number two. This for my mom.
So 1, 15, 19, and 22 are not admitted. So then all this can go by.
Yeah, I put number 22. Okay. Victoria, make sure I get this for my mom as well.
Yes, it's worth it. $1 is enough.
Ah.
He's already, he's been in line for that.
All right, thank you. And have they conferred over the exhibits and they agree?
Well, I don't know where Mr. Bloomquist is.
Jason, can you look at the exhibit to make sure that those are all the exhibits? Oh, okay.
It's not here.
Okay. Yes. Oh, they're here? Destiny Blair? Destiny Blair? Can we call them? Because I haven't seen them yet.
If he could move in one, because I gotta talk to him. Thank you very much.
Yes. 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 All right, thank you. I'm taking your call. Yes.
Are we okay for a reset?
Oh, sure. If you'll grab the file.
Sorry, Judge.
Judge, may I
Yes.
approach?
It's an MTR.
Marisol Renee Vasquez, is she still down there? All right, here you are. You're welcome. Could I see the file on Marisol Vasquez? Jesus Santoro? Ms. Abrams, on this case, the defense counsel is requesting a reset. Have you had a chance to talk to the defense? All right, if you'll just let her know the reason for your request for a continuance, and it'll be fine. All right, on this.
Thank you.
You're welcome.
I've
So,
already conferred with defense counsel and he informed me of what he requests from the court.
all right, so when are you asking it to be recalled? Okay, all right. Oh, yes. Ms. Ferguson, could I have a 30-day reset?
Yes, ma'am. Give me 1 second, Judge.
Hey, we try. All right, well, you know what, of course, my mom always says that other than being at home, where's the most time you spend your place at work? And so the cases we deal with on a daily basis, if you're having a hard day, hopefully you see the flowers and it makes you smile. And then you can say, you know, life is beautiful, you know? Oh, we did. You know, she always says, this is the best Mother's Day, or this is the best Christmas, this is the best birthday. So I wasn't there for Mother's Day, but I always go for her birthday. It's April 22nd. So it's sort of
Excuse me.
an overlap. Yeah.
Could you keep this for defense
Yeah.
counsel?
And
Should be.
usually when I leave, I'll put a card underneath her pillow. So when I leave it, I'm on my way back. And then when she finally goes to bed, she'll call me. All right, so we're gonna have you come back on June 10th, okay? All right, thanks for dressing appropriately for court. If you'll have a seat, once your attorney brings you the reset form and you sign it, then it'll be done. All right, and so what I can tell you is I'm looking at the allegations in your motion. I don't take any of it as true, but you better stop, all right? All right, thank you. Oh, you're welcome.
Okay. They're just gonna flip it.
It's June 10th.
So we have to go. Okay. So we're.
Yes.
Is it, all Docket? It's just a bit. Okay, she has to pick up matters until the applicant.
Just give me a moment.
Yeah. Yeah. All right. You are.
Jenna,
Yes.
do you have a file on Marisol Vasquez? And counsel, you're here for?
Monica Wade, Your Honor,
Right.
MCR.
You need to have them pull the file.
Okay, the state's, I just wanted to let you, the state was gonna be withdrawing the MTR.
All right, once they, just have them pull the file and I'll take it up.
Okay.
Here it is. Sorry about that.
I'm getting. I need to start some.
No, because they're withdrawing.
Oh,
So I just need that.
All right, David Warren Brown. All right, who's here on Sergio Garcia?
That's me, Judge, and we are ready.
All right,
Go ahead.
Mr. Garcia.
It was going to be a contested MTR, but the state is going to withdraw the MTR.
And state, what's the reason for withdrawing?
Come to a proposed agreement, Your Honor, on the term of the MTR. Well, this is just my notes.
I don't have the withdrawal sheet.
Okay.
I'm sorry, I wasn't on the slide yet.
All right.
Sorry.
Yeah.
So how's it going?
It's going. How are you?
All right. So have you already went on your trip or is it coming up?
It's coming up. So we went on a CLE about phones, which was very interesting. All about phones and the metadata and the dumps. And so that was very interesting.
Tell them to get that for discovery quickly. How can you receive it quicker than what they're doing?
Yeah. But then we're gonna go to Mississippi in January.
Oh, what do you got? Which part of Mississippi?
We're gonna go to Biloxi. We gamble.
Oh, well, good luck.
I call her.
Yeah.
She's putting it up now for you.
All right, thank you.
I'll sign it.
All right, so what's the reason for the withdrawal?
So, Ms. Jones called me on Friday. We had previously set this for a contested, I guess, after some further investigation. We reached an agreement that they would withdraw the MTR, we would alter and amend, put it for IOP and a no contact order. That was more suitable with the evidence that they had.
Probation. On this case, do you need an updated TAP evaluation?
Yes, Judge.
All right, so Ms. Christian?
Yes.
Based upon what I'm reviewing and the motion to revoke, I do have concerns with the drug use.
Okay. You need to talk to us?
So the TAP evaluation is going to be in custody.
Okay.
My understanding that should be relatively quick.
Alfredo Campos.
So I'm gonna alternate amend a TAP evaluation, follow TAP results, because I don't know if they're gonna
Recommend anything
yes.
or something?
And then, Ms. Abrams, I'm gonna ask for 120 sober meetings and 120 days upon release. So that'll be a TAP evaluation in custody. Follow TAP results. Plus 120 sober meetings in 120 days. Is there anything else you need from the court to be successful?
I just don't know why it didn't pass anyway, that's the thing. At that time, I was taking medicine for a broken tumor.
Mhm.
And I did go to a meat market to get antibiotics, my face was sore.
So here's the thing, when you're on probation, and this is what I tell everybody, everyone, please whisper. Your life is not your own, right? So anytime you take any type of medications, you need to make sure that a prescription is given to probation. So when they test you, they can see whether or not that medication will cause any type of false positives. And here's the other thing. I don't know what's going on between you and the complainant that's listed. Sure.
I have no idea who that's. I've never heard that before.
Well, that's good for you. So you don't need to be around that complainant, okay? So what you're on probation for, if your probation were revoked, and I'm sure your counsel has told you this, you're looking at life in prison. So don't step wrong.
No, I'm not doing that. I mean, I've got my driver's license, I got a vehicle, and the only way I found out about this warrant was I actually got pulled over and the officer was gonna let me go with the warrant.
But then
But
this,
he thought that I had a warrant, but I was surprised, just surprised as anything.
okay.
I would just I'm scared out there.
Okay.
I'm watching on thin ice, so I watch every step I take.
All right. So here's the thing, if anything goes wrong and you feel like you have some issues with anything, all you have to do is, in this court, all you have to do is let your probation officer know.
That I understand.
And if that doesn't happen, you can come in here and let me know, okay? You wanted to address something?
Yes, Judge, I just wanted to confirm that you wanted the no contact also in the limited condition.
Yes, and yes, no contact with the complainant.
Thank you, Judge. And if I could get my withdrawal form whenever you.
Yes, you can. Let me see where I put it. Paper is being, here we are. You know, when you have so much on your desk, paper starts disappearing.
It's like that sock in the dryer.
Oh, yeah, it's like, what do you call it? What do they say when things disappear? Who's doing it? The fairies or something? Yes. Okay, let's not bring tummy knockers up in here. That's very scary. All right. All right, thank you so much. I love your pen.
Thank you, Judge. May we be excused?
Yes.
Okay.
Go through it.
Oh, and Ms. Christian,
Yes, ma'am.
if for some reason you believe the TAP evaluation is taking too long in custody, you can come back.
I'll let you know, Judge.
All right, thank you.
I need it.
Okay,
That's actually better than I thought.
all right.
Communication is up there.
You got one?
We don't have carbon copy. You know how you have to give a carbon copy?
Yeah. Okay, and the other thing is up there.
Yes. Fernando Ramos. He's in top. The old man way on top of the block. Oh, she's the older. Oh, it's the teacher. Yeah.
Garcia.
Yes.
David Brown. Ms. Ferguson, if you can see where his attorney is. And did you check on the person who's being sworn in?
No, not yet, Judge. I was talking to me about a situation. Oh, yeah. Well, if you have to, then she go.
You done?
He's not done.
Oh.
Explanation.
Okay.
Destiny Blair. Thank you.
No. Yeah, on Mendoza. Interpreters here. No, it's first appearance on indictment. The family violence.
Getting sworn in by the judge. Thank you. This is Norma Ferguson. I'm just gonna leave it for the 180. Thank you.
Hey, Woody. Can you trade places?
It's funny.
You guys.
Raul Lopez.
Ready, Honor. We have an interpreter.
All right. Hello. Hi. So, Mr. Lopez, is your client a US citizen or no?
He is not a citizen, Your Honor.
Do you have an immigration attorney?
Oh, we're gonna request one from the MAC.
All right. So where are we on discovery?
Almost gathered all evidence except defendants was submitted to a SANE exam that has been submitted to the lab. I need to check with the lab to see if they have finished testing that and provide the results of that to defense, along with confirming victims interview at Child Safe and making that available for defense to review.
All right. And was there any CPS records?
Yes, there were, and those are available. I don't know if defense has those or not, but if he doesn't, we can provide. I can make a copy. I don't have them right now, but I can make one and have one ready for him.
All right. And do you need me to sign a protective order?
I will print one up for you, yes, Your Honor.
Norma, recall this case for. I'm going to recall you for July 28th. And that will give your attorney chance to speak to immigration. And
Thank you,
that will
Judge.
give the state, if there's any type of DNA evidence, the chance to at least have that available. Do you
Thank you,
have
Judge.
any? You're welcome. Do you have any questions?
No,
All right.
Thank you, Judge.
All right, thank you. Yes.
I need your.
Sure, hi.
Nice to meet you.
Nice to meet you. And what's your name?
Have a look again.
All right, good meeting you.
Yeah.
Thank you. July 28th.
I'm still on hold. Judge.
All right.
Yeah.
Ready on Mr. Gouty.
Brown is there, David Brown?
He's up here.
Oh, Donna Venus uses.
All right. All right, and counsel, your client has not shown. Brown?
Yes, Your Honor.
Your client hasn't shown. So have you had any contact with him? All right, could I have someone from the state for a non-appearance, please?
Is this a commercial bond or personal bond, Judge?
Let me look it up, just one second. Odyssey is moving slow. Either way, counsel, I'm inclined to issue a judge's warrant, just in case, because sometimes people are not getting notice. I'm unsure if that's happening in your case, since you said you had no contact with your client. So with the judge's warrant, it will be easier to recall that as opposed to issuing a bond forfeiture. But let me see what is in here. The little circle is going round and round. How have you been doing?
Chair, because probation you can talk to. To update your information. Yeah, just go say, excuse me, excuse me.
Yeah, it's a commercial one. All right, court is calling 2025 CR 0034882 State versus David Warren Brown. Could I have parties announced for the record for the state?
Andrew Harris, Sadelman.
Valentina
Defense.
Colbert on behalf of David Brown.
All right, this hearing was scheduled at 9 a.m. It is now 11:32 a.m. Court called the docket. The defendant did not answer. Deputy Laura, did you make an announcement?
Yes, Your Honor, nobody's out there.
All right, state.
Forfeit the bond, issue a warrant.
All right, and defense, have you had any contact with your client?
No, Your Honor.
The court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Yes.
Back on the roll. And
I will make a copy and provide that to the.
Great, thank you. I'll drop by tomorrow.
Okay.
Thank you.
You're welcome.
Thank you.
And that's a judge's warrant, Jenna.
No, I don't know. Oh,
No. I'll be back in 5 to 10. Service calls.
If it helps any like she's been like putting in my books and visiting me. Can I get approved, for calling them stuff? Like she puts money in my books every week.
This is like be a violation of no contact. They can charge you just like that. So be careful about that. And don't talk about the cases of anybody else, like any family members and stuff. Only what you tell me is confidential and privilege. They can't use that against you, but anybody else, they can try to use that. So they listen to the jail calls and all that shit. So be careful.
Thank you.
Monica Wade. Oh, yes. What are we here for?
Motion to withdraw a motion to enter adjudication of guilt. The state cannot produce the witnesses that we need to substantiate the violation allegations.
All right,
As
so,
I understand it, there is only one violation allegation.
yes. All right, and who are the complainants alleged to be in this case?
The complainants, if I remember correctly, is Richard Slackner, SLAGTER.
SLAG.
TER.
All right, you're not to have
You
any
need to talk to
contact with this person, do you understand?
Yes.
You are on
Let's see what he.
probation,
Oh, no, you're fine. Just.
and what you're looking at is potentially 5 years in the prison, do you understand? All right, the court is going to sign the motion to withdraw. And there's to be no contact. Ms. Abrams, there's to be no contact with the complainant, Richard, SLAGTER.
GTER.
And if you can give that to Ms. Abrams. Is there anything else?
No, Your Honor.
All right, thank you for dressing appropriately for court.
Your Honor, does it require a court order to take off the GPS as condition of bond? They'll automatically do it.
If they should do it. But if you need an order, just let the court know.
Okay.
Who's here on Alfredo Compass? Okay, so all right. On this case, where are we on discovery?
Your Honor,
Oh, go ahead.
I conferred with the state judge with regard to discovery. I believe there may be some outstanding videos. So I requested the state so they can make efforts. To locate them.
Yes, I will look into the videos, Your Honor, and provide those to defense if they're able to be found.
All right. I need a 30-day reset for discovery, please.
Yes, June 10th.
All right, so we'll have you brought back on June 10th. All right, thank you.
Have a seat there. Is that for discovery?
Yes.
Thank you.
Who's here on Mario Whitty?
Mr. Whitty?
Morning. Yes.
Your Honor.
Yes.
This will also be a motion to withdraw the MCR. I reviewed the file provided to me by Supervision Officer Simonelli. The defendant has a successful affirmative defense for due diligence for the condition. and
I
violation
imagine so,
allegation.
because this is from 1999.
Yes, Judge.
Isn't it Prince? We're gonna party like it's 1999. This is during that time frame. All right. The court will sign the motion to withdraw.
Judge, I need direction on if the termination will be unsat or sat.
Well, has he successfully completed it? If he hasn't successfully completed it, then it'd be terminated unsatisfactorily. If he successfully completed, then it'd be terminated satisfactorily.
If I remember correctly, he had not completed his supervision hours.
All right.
Judge, there are no program or classes or community service hours listed. There is a remaining balance on the account.
But he did have a financial means to pay it, so.
All right, so y'all have to present evidence of that, because I don't have any evidence of that. So it's gonna be term unsat. All right, thank you. Good luck to you.
Thank you, Judge.
You're welcome.
Yeah, uncle.
I have two please this morning.
He's gotta go to 15.
15, okay, next door.
Who is here on Miguel Velez Jr.? So on this case, where are we on discovery?
I believe I have it all, Judge. We are resetting for possibly a dismissal. There's some things they need. So we just need about 30 days for my client to be able to collect the proof I need to give them, and then we should be able to resolve this case.
All right, Ms. Ferguson, I need a 30-day reset for disposition, and that will be your plea deadline date as well. All right, June
Perfect.
9th.
Yes,
Once you
June 9th.
sign the reset form, you are excused. Thank you for dressing appropriately for court.
Thank you, Judge.
You have a good day.
You too.
It's growing, but it's so long. But I'm amazing.
Who is here? And Amanda Drummond? All right, Ms. Drummond, you'll come down. So they're recommending for you that you go to safety because you didn't qualify for felony drug court. So, and you were medically disqualified for DDRF.
Okay, if I might speak for that.
Yes.
The drug court refusal was because she had a warrant in Wilson County
Okay.
that had since been cleared, so she would qualify for drug court.
So what I'll do then is I'll alter them in conditions. If y'all will refer her then back to felony drug court. And
In
yes.
addition, she's been taking drug treatment while she's been at the jail.
Awesome.
They've already given you time, so you.
She's finished that and doing well, and they have her on a maintenance program, so if she uses, she gets sick, so that's a pretty good incentive.
All right.
So we refer to felony
Yes.
drug court?
Since she lives in Karnes County, would it be possible to be treated?
If she lives in Karnes County, they're not gonna accept her in felony drug court.
There
Right.
was,
So I was wondering if we could, since she's been getting treatment and continuing on a maintenance program. Her job down in Karnes County she's been working for a firm that fails hay. That season's about to start again, and they've held her job open. But they won't be able to continue holding her. If she doesn't have a job, she can't afford to pay probation anyway.
Well, no, she's either gonna go to safety or go to felony drug court, and if she's out of county, felony drug court won't accept her here in Bear County. If you want to check and see if there's a felony drug court in Karnes County, I don't know if there is. And see if they will place her in the program there.
Okay.
Judge, I believe we spoke about this the last time she was here, before she was referred to felony drug court the first time. And she indicated that she did have somewhere where she could stay here, which was at her mom's address in Bear County.
Oh, all right. So then we'll do a referral to felony drug court.
Okay.
All right.
And if not accepted, do we move forward with the safe P?
We'll come back and I'll see.
Okay.
If that's still a recommendation from probation.
Okay.
Okay. All right, so Ms. Drummond, what's gonna end up happening is you're gonna be referred to felony drug court. If for some reason that doesn't work out, we'll bring you back and we'll figure out something, okay? All right, thank you.
Thank you.
You're welcome. All right, who's here on one Cruz? All right, we're here for discovery. And you've received the CPS records?
I have, yes.
All right, is there any other outstanding discovery?
Yes, I made that request.
All right, what is outstanding?
So I am needing phone evidence, home surveillance evidence that the CW have handed over to law enforcement. That is not in any of the discovery.
All right, do you have the surveillance?
I believe we're working on getting on that, and as soon as we can, we will provide that to Ms.
I also made a request for counseling records.
Brown.
Okay. So we need home surveillance and the complaining witness has that?
Your Honor, I was just alerted that these exist from defense's knowledge. At this time, I haven't confirmed their existence, nor have I confirmed the existence of the counseling records. Defense counsel sent us a request asking for these items, so as soon as we confirm their existence.
All right, and the phone records that you're saying, whose phone records?
So it would be home surveillance that was on the phone of the victim's mother, and she had turned that into law enforcement on my review of the evidence, but I do not have that in any of my e-discovery. The same can be said for a prospective witness who offered that too. I don't have any of it.
All right, and then the other thing you said, medical records or?
No, within the medical records, there was reference to counseling that was to begin on December 19th of last year. These medical records were from October of last year, so we're needing to see if there was counseling and there are records of that.
All right. So let me see here. I'm going to give you all a little extra time so that you can obtain this. I know how it is sometimes with third parties who have video and you actually don't have them and it's a layperson.
Yes.
We'll recall this. Are you available for July 21st?
Yes.
All right. So we'll recall this for July 21st. Is there anything else?
Nothing further.
All right, thank you.
Thank you, Judge.
Thank you. Who's here on Jamal Fisher? And are you all ready to proceed?
We are, Judge.
Court is calling 2024 CR 011671 State versus Jamal Ricardo Fisher. Can I have parties announce?
Ashley Jones for the state.
Megan Enriquez for Jamal Fisher.
And are you Mr. Fisher? To review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, did you understand it? Are you the same Jamal Ricardo Fisher who was placed on deferred adjudication in 2024 CR 011671 for the offense of injury to a child, elderly, or disabled person with intentional bodily injury on January 27, 2025 for a period of 4 years? Is that you?
Yeah.
All right, state.
Yes, Your Honor, the state is going to proceed on violation of condition number 4. On or about the 28th day of February 2025 in Bexar County, Texas, the defendant Jamal Ricardo Fisher did then and there fail to conduct himself in a proper and orderly manner during an inmate video conference meeting with the Bear County Community Supervision and Corrections Department Supervision Officer in violation of condition number 4.
How do you plead to that? True or not true?
And the state will waive the remaining violation.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there proposed agreement?
There is not, Your Honor.
All right, state, what are you requesting?
Your Honor, at this time, the recommendation from probation is amend for DDRF. I do believe that the defendant has undergone a mental health and a TAP substance abuse evaluation, both recommended DDRF, and at that time, that is the state's recommendation as well.
All right, thanks.
Yes, Your Honor, and that was the basis for his outburst with the probation officer. He does deny some of the things that he's alleged to have said, but he does ultimately agree that he did use profanity that was inappropriate. That's why he did decide to plead true. I believe what happened is that at the very beginning, when he pled for deferred, he was misinformed. He believed that he would be getting out. He says he signed for probation because he thought he would get out that day or the next day. But instead he was held in custody, explained that that's routine and normal and that happens all the time. And so he waited in custody for 3 different evaluations. I believe the TAP, the mental health evaluation, and what was the other evaluation? A drug court evaluation. And so he waited in custody for those, and ultimately the mental health evaluation recommended DDRF. So when the probation officer came to meet with him, he says that the video wasn't on, he could hear him, and he was explaining to him that there were going to be new conditions, but he didn't have new conditions in front of him. He, in his mind, didn't feel that DDRF was appropriate for him. He says he doesn't have a drug problem, and since it's dual diagnosis, he doesn't believe his issue is drugs and that he's not a drug user, and that he was just trying to explain that to his probation officer, albeit with profanities, because he was upset that the probation officer explained to him that there was a long wait, and that upset him. And so that was what got us here today, was that interaction with the probation officer. But leading up to that, he was further upset, and he wants to explain it to you in his words as well, but this is kind of a synopsis of what he's told me.
Well, let me explain something, sir. I go over conditions with people in great detail. I go over conditions of probation with people in great detail. And I always ask people if they understand what they're being ordered to do. And if they don't understand, I explain it to them. So what I can tell you, when I place you on probation, what I said was a $1,500 fine, probated, 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, 100 hours of community service restitution. That was to be waived once he completed anger management, affirmative finding of family violence, no contact with the complainant, and Madam Circle, which was an address, referral to felony drug court for their dual diagnosis program, a MIC evaluation, and DDRF. That's what I ordered. And so what I said was, we're going to try felony drug court with their dual diagnosis because it doesn't take them as long as DDRF. But the court did order you to go to DDRF, or at least be evaluated for DDRF if felony drug court doesn't accept you. And the reason why I ordered that was based upon the evidence that was presented to the court on the day of sentencing, that there are some mental health issues. Now, if I send you out into the world and I do not give you help from your mental health issues, you know what's going to end up happening? You're going to end up back here and you're going to say, well, judge, your attorney will say, judge, he needed mental health treatment and you didn't even try to give it to them. That would be my fault. That's on me, right? But when I give you things that you need to be successful on probation, you have to sign for those. And let me explain to you, everybody has a right to their feelings, to be angry, to be upset. But at the end of the day, guess what? Everybody's just trying to do their job and they're hoping that they will have a nice day at work. Some people, it's like, gosh, I was supposed to be retired, or I really didn't want to do this as my career. Now I got to suck it up and just continue to do it. And I really don't like it. It's not my passion. Some people, I was only supposed to be here for 1 year, then I was going to trade school or going to college and do something else with my life. So everybody is just trying to have a pleasant day. And if everyone would treat everybody with kindness, it would really go a long way, because everybody's just trying to do their job. So what I'm telling you is, I have ordered DDRF. You're gonna have to sign for DDRF. If you don't want to sign for DDRF, then what I will do, I will revoke you and I will sentence you to 3 years in the prison. So you have two choices. And these are the only choices you have. Don't come to me with a third choice. Two choices: sign for DDRF or 3 years.
Can I just?
Sure.
Ma'am, I never once had an issue with DDRF, and I know what you recommended. I never saw DDRF, as I was explaining to my lawyer. When my probation officer met with me on that Zoom call on the 28th, that was the first time I'd ever got actually a chance to meet him. I tried calling him, my mom and dad had tried calling him, my previous attorney tried calling him just to say hi. I'd never even heard of it.
But you know what the appropriate response is?
Ma'am.
If somebody wants you to sign a contract, at least in this realm, in the 187, you need to say, well, I'm confused, sir, because I don't believe the judge ordered DDRF for me. I would like to go back to court. And then that would have been the end of it. Everybody would have been like, okay, and you would have came to court, and you know what I would have done? I would have said, Mr. Fisher, I ordered first felony drug court, because it's a short wait time. And then if not accepted by felony drug court, DDRF. And then that would have been done. I always tell people, don't get upset because things are not going your way. If you are confused about something in this court, you can always come back to the court and say, Judge, they want me to sign up for DDRF. It's my understanding I'm not supposed to sign up for DDRF.
I think, maybe that my problem wasn't with the recommendation, and if he had said that, I would have been like, okay, well, this is my thing. You gave me, I thought it was a blessing, still think it's a blessing to be on probation. I don't care, DDRF, whatever it is, if you're asking me that, you're the judge, so I'm not gonna say no. When the probation officer, all he said, his exact words, I was like, she wants to go to DDRF, and I didn't know if he meant to say she was talking you or someone from the evaluations. All I asked was, what's DDRF? And his exact words were, you're going to have to wait a minimum 6 to 8 months to get a bed, and then it's a 4-month court. That's when I lost my cool. Then even after that, he didn't say these are conditions of your probation or explain what DDRF was. I was never upset about the recommendation. I didn't even know DDRF was a thing. The only reason I reacted the way I did was he said, you're gonna have to wait 6 to 8 months for bed. And I didn't know what that was for. I'm not gonna say no.
So here's the thing. So if you want DDRF as opposed to the prison term, all right. So I'm gonna deny the motion, alter and amend conditions for DDRF. Council, what I'll do is, Ms. Ferguson, I need a phantom date for a setting of 60 days. We'll come back in 60 days to see where he is in the process. Okay. All right, Ms. Ferguson, 60 days, phantom date. All right, so we'll be back in July 10th. July 10th, it's not going to appear in the system, because if we have it in the system and they're ready to transfer to DDRF, they won't, and you'll lose your place. Okay. So it's just a phantom date, but everybody here knows July 10th. Okay. All right, probation, is there anything else he needs? All right,
Just to
thank
be
you.
clear, Judge, so that he's admonished here on the record. So today he will have to sign his new conditions agreeing to go to DDRF, and he'll be placed on the wait list as of today.
Yes.
No.
No.
The wait list doesn't start today, Judge. You still have to go through an evaluation.
All right, so you still have to do a medical evaluation and everything of that nature, okay? All right, thank you.
Thank you.
Thank you, Judge.
You're welcome. You're welcome. Thank you.
Okay, perfect. Thank you.
All right, who is here on Alexandra Hernandez Mejia?
Ready, Your Honor.
And after that, it will be Veronica Wicks. And then the court is going to take its recess. Court is calling 2025 CR 003-593 State versus Alexandra Hernandez Mejia. Could I have parties announced?
Jason Gear here for the state, Your Honor.
James Seeloff for the defense.
And are you Hernandez Mejia? All right, have you received all of the discovery?
Yes, I have, and I downloaded it already and viewed it with her.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count one and proceeding on count two alone.
Any objection?
That's our understanding and no objection.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand in count two, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Yes. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she does.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on count 2. There's a $2,000 fine. State recommends deferred adjudication, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea? Yes. Defense?
Yes, that's our understanding. We don't agree with the latter part,
What's the latter part?
the non-agreed part. Huh?
Below the line.
Below the line.
Okay. All
Okay,
right.
I'm sorry.
That's okay. State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There has not been.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, and no contact with Stephan, Stephan Palacios Cruz. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes. He is the father of your child, so we do.
All right, so here's the thing. What I'm telling you is, do you understand that those are recommendations from the state? Do you understand the court does not have to follow those recommendations? Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State exhibit number 1 with all of its attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we're ready for sentencing. There's no reason not to.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, as far as the gentleman that no contact with, and I told the prosecutor at the end, he is the father of her child.
Mhm.
So there has to be contact. This is a situation where they were trying to, I guess, do a business that didn't work out too well. She does have a marijuana problem, not a cocaine problem, but she does have a marijuana problem. She's been smoking since 16. No cocaine though. That was for sale. I'd like the court to take into account and ask for 4 years instead of 5 years. Lower the community service and probate the fine because she's court appointed and she's a single mom. She has no money coming in from the father, I guess, on a permanent basis for child support. And so I asked the court's consideration in those matters.
All right, how old are you? Where's your child? All right, and how old is she? All right, so basically, the grandparents are taking care of the child. No, but do you and the father take care of her?
Yes.
All right, so how are you all taking care of child when you're using marijuana and you all have all this cocaine in the vehicle and a gun? So I'm telling you right now, if your child were in that car, ended up using the gun, accidentally killing themselves or killing somebody else, you would be boo-hooing, asking for a GoFundMe page for a funeral. And then you're using cocaine, and then you can't stop using marijuana. If you're drug tested today, what are the results going to be? All right. How often are you using marijuana? All right, so here's the thing. I'm going to grant your application for probation. I'm trying to discover what conditions to place for you. So how often are you using marijuana?
It's slow down a lot. I wear some.
And what do you do for work? That's the new West telemarketing.
They do it at home, she says. I've never heard of that, but maybe that's why they get so many hangups on my phone.
All right. And how far did you go in school?
When I was
All right, what are you planning on doing with the rest of your life? What's your dream job?
I wanted to work in the office, like you said, she was saying.
All right. Well, what I can tell you is I'm not going to allow you to have contact with Stephen Palacios Cruz. It appears to the court that the grandparents are taking care of the child anyway. And on it,
She just reached out.
when you all are riding around with drugs, marijuana, and guns in a vehicle, where was she? With his mother. So basically you have grandparents who are being parents, and I'm sure they are just devastated with worry whenever your child is along with you two, because you all are doing crazy things and you both have a drug issue and then trying to sell cocaine. Not going to happen in this court. Is Child Protective Services involved? I don't know why they are not, but that's not my call. I can't pick up the phone and call them and tell them, hey, look at these people here who need Child Protective Services in their life. All right, this is what the court is going to do. There's a $2,000 fine that will be probated. 6 years deferred adjudication. If she completes everything early, I'll consider early termination.
She's gone a little bit more than the state asked for, but you can get off early if you do everything.
There's to be regular reporting by Zoom or in person. There's to be regular random UAs, tests for levels, do a referral to felony drug court, and a TAP evaluation out of custody. There's to be no unsupervised contact with minors,
With who?
with minors. So you're not to have unsupervised contact with your child until you test negative.
That means your mother has to be present while you have the child.
I just.
Okay.
See, as I said, the grandparents are taking care of the child. I don't know what's happening with this generation. There's gonna be field visits one time per month until further notice. There's gonna be 200 hours of community service restitution. 100 hours will be waived upon completion of parenting classes. The other 100 hours will be waived. I'm requiring parenting classes, but the other 100 hours will be waived if you obtain some type of trade school certificate or complete some higher level of education. There's to be no contact with Stephan, STEPHAN, Palacios Cruz. There's to be 120 sober meetings in 120 days. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors, and to follow all TAP evaluation recommendations. There's to be restitution to SAPD for drug testing. Probation, is there anything else? Yes.
Thank
And
you.
then before she has the unsupervised contact, come back to the court to remove that.
Would you consider your contact order at that time also, or?
But with regards to the defendant,
Stephan?
no,
That's the father of the child. I don't.
yeah, that relationship is not working out for you, and it's, well, maybe it's working out for you, it's not working out for your child.
You understand? Do you have any questions for the judge?
And basically it appears to the court that the grandparents are raising this child anyway. You all are just fly-by-night people who happen to produce the child. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. I'm going to tell you what I would always tell my clients on the family law side. Where you are today, hopefully is not where you're going to be at the end of everything. Everybody hopefully is working on improving themselves. Do you understand? So you need to work on improving yourself for you and for your child. If your goal is, you know what, I love this Stephan guy, I'm going to ride or die with him, then you need to excuse yourself from your child's life. Write her a little letter explaining to her when she's 18 that you chose this man over her, and that you're just going to be the fun person who comes in once in a while and gives them a gift. But don't keep breaking their heart by doing the wrong things. Do you understand? All right, good luck to you.
Thank you, Judge. May I be excused?
Yes. All right, this is the last case before we take our recess. Veronica Wicks.
Ready, Your Honor. Your Honor, I have a meeting. Do I come back at 1:30?
Yes.
Okay, I'll tell my client.
Sure.
And I'll come back at 1:30.
All right, thank you.
Thank you.
All right. Hi. Court is calling 2025 CR 003243 State versus Veronica Wicks. Am I pronouncing your name correctly? All right, could I have parties announced for the record? State,
Andrew Harris Edelman.
defense,
Fernando Ramos for the defendant.
and are you Ms. Wicks? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
There is, Judge.
I don't have an application. Did y'all file an application?
We did, Your Honor.
I have it.
Okay.
All right. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand, counsel? Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yeah, John.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Wicks, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? Yes. According to the plea, the state recommends deferred adjudication. They will take in consideration NIMAG number 761063. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Yes. Counsel, are there any such motions?
None.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offers exhibit 1 and attachments.
No objection, Your Honor.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Could we waive our right to have a PSI and ask to be sentenced today?
All right, anything you wish to say on behalf of your client?
That my client was born in Arizona, lived in Bear County for the last 9 years or more. Is employed in landscaping that he with her husband. Has no children and hopes that he will grant this application.
All right, is that true? You have no children? All right, what are the ages of your children that you do have? I'm sorry? I know you're saying you don't have any of them with you, but what are the ages? So you have a total of 2 children? Who are they with? So have they been adopted? All right. And what is the writing on your face? Okay, and who is Victor Castillo to you? All right. And does he have any children? And what are their ages? Okay. And other than this landscaping business, do you have any other employment or means of support? All right, so you're gonna have to get employment. Is there a reason why you're not working? I'm sorry, what? Okay, I am so sorry. My allergies are acting up. Would you repeat that again? All right, are you a citizen? All right, so why are you getting paid under the table? All right, so here's the thing. I know that sometimes people do this under the table thing, but that's gonna catch up to you. All right, so you're gonna have to get your ID and whatever else you need so that you can stop being paid under the table. Because when people are paying you under table, who knows? Maybe they're not paying you what your value is to the company because they can do that because you don't have any ID. And their whole thing is who you're gonna tell. You're committing an offense by accepting payment under the table. You understand? And you live with this Victor Castillo? Who all lives in the household?
In my house and then his boss and his wife and his kids live in New York.
The boss's wife
Yeah, the boss and.
and their children? All right, this is what the court is gonna do. The court is gonna sentence you to 5 years deferred adjudication. If you're drug tested today, what are the results gonna be? All right, there's gonna be regular reporting by Zoom and in person, regular random UAs, a TAP evaluation out of custody, follow recs. We'll do a referral to felony drug court. Proof of employment within 30 days. No employment as a home health care provider or with minors. No contact with minors. Field visits 1 time per month until further notice. 200 hours of community service restitution. 140 sober meetings in 140 days. And take in consideration NIGHTMAC number 761063. Probation, is there anything else?
You said 120 as far as the service hours.
200 hours of community service. Yes.
Nothing else there.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. To be successful in this courtroom, communication is key. If there's an issue, let probation know. If you feel they're not addressing it, you can always come to court. And I will tell you, I'm not a doctor, but methadone, that's not supposed to be a lot. You're on it for life. You understand? So you're going to need to start doing your sober support meetings and getting with the sponsor. All right. I don't want you to be one of those persons who ends up in prison for the rest of their life, or somebody has to identify your body. You understand? All right. Good luck to you. You're
Thank you,
welcome.
Judge.
Thank you.
I apologize, I misunderstood my client, Judge.
Oh, no problem.
May I be excused?
Yes.
Thank you.
All right, everyone. The court is going on recess to All right, everyone, the court is going on recess to
I think because my client didn't have injuries, I think I am gonna request both of self-defense and it's a third party. We already agreed to leave the languages into the second application.
Okay.
But over the weekend, I was thinking, well, we have injuries, stuff like that. You know, the
Okay.
multiple.
if you would like to, he said he wants self-defense. Mr. Bloomquist,
Yes.
if you'll speak with the state on what you would like added to the charges, I'm going to call the docket. All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you are here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Leslie O'Banion, custody. Efren Martinez Soto. Juan Cruz, custody. Thank you. Christopher Mariscal. Humberto Rodriguez. Zoe Brooks. All right. Alfredo Campos, custody. Guillermo Mendoza. Jenny Guerrero, custody. Alex Bacon. You know what? That may really be the degrees of separation to Kevin Bacon. Alex Russell Bacon. Veronica Wicks. Carlos Vasquez. Paul Inaosa, custody. David Brown. David Warren Brown. Jonathan De Hoyos. Jonathan Alfonso De Hoyos. Jalen Ross, custody. Is this Stefan Palacios Cruz? Thank you. Alexandra Hernandez Mejia. Alexandra Hernandez Mejia. Marisol Vasquez, custody. Dominique Escobar. Jalen Ross. Jesse Garza. Ortega. Guillermo, is this his first or last name?
The Gumar is his first name.
All right, they did the comma wrong. Gamar Mejia Ortega, custody. Bradley Galan. Bradley Tyler Galan. Miguel Velez. Gregory Jennings. Guillermo Mendoza III. Jack Evans. Grace Rocha. Amanda Drummond, custody. Arturo Villanueva is by Zoom. Jamal Fisher, custody. Mario Huwiti. Mario Huwiti, custody. Gerardo Herrera. Gerardo Marino Herrera.
You're on that, Judge.
Thank you. Jesus Santalo. Sergio Garcia. Monica Wade. Thank you. Is there anyone who came in later, your name was not called? Yes, what's your name? Okay. Anyone else? All right, everyone. These are the rules of the court. We are doing closing arguments this morning. So once all of the jurors are here and the jury charge is completed, we're going to go into our closing arguments. So if you have someone who's in custody, they're not going to be brought out right away because we're going to do closing arguments first. Once the closing arguments are concluded, I'll take up the daily docket as usual. Everyone, you may confer. All right, State, on this case, Rendon, have you had a chance to review the request by the defense?
So I guess there were two things that he wanted to address regarding his proposed instruction. I don't necessarily have an objection to the law regarding presumption being in a jury charge. I would just ask that it track the statute.
Okay.
And then you can address your other point.
On that one, it does track the statute. It just has, it just basically says that,
Okay. All right, so
yes.
we're all agreement. Presumption tracks the statute. And then we'll need to put in the definition of robbery.
I agree.
Okay.
Bro, take a roll.
And defense is saying that they want self-defense and defense of third parties.
Yeah. And over the weekend, as I was considering the evidence, and I was,
Oh, no problem.
yeah.
No explanation needed. I'm just wondering if there are any objections to that.
No.
So I was doing research over the weekend, and I think because ag assault is a result-oriented offense, and because the level of force that was used caused serious bodily injury, it is deadly force, and so I don't necessarily believe that they're entitled to the regular self-defense instruction in the charge.
Okay, so I'm sorry, could everyone please whisper? And we're not on the record yet. I'm just trying to figure out where everybody is and what you want. So I'm sorry, could you repeat that?
Yeah, so I guess I am objecting to the regular self-defense coming in just because I don't believe that he's entitled to an instruction on self-defense because aggravated assault is a result-oriented offense, and the level of force that was used in this case was deadly force by definition because it caused serious bodily injury. And so I did have some cases that support that. It was Farrell v. State, and I think that just cites it was like.
All right, so here's my question, defense, with regards to I see the defense of third parties. I can see that.
Yes, sir.
But with regards to his self-defense, I don't see how you get self-defense for him when it's when it is the complainant that is for lack of a better term, engaged in some sort of altercation.
And the reason I think it's relevant, Judge, is because it's just like the law of parties for my guy, it's the law of parties for them.
Mhm.
So there's all these people having this melee. There's the other guy that's involved. He's concerned that he may come back. He's got the girl who scratches his neck and then him as well. So it's basically almost like a law of party situation where he's being assaulted. This whole group is being assaulted by multiple people. And that's why I think it's relevant, Judge. And then let me just address the issue on deadly force versus force. So deadly force is either force that's known or intended to. And I think it's very arguable that a person would not know. And I actually have some really good examples of that, where police officers use knee strikes to the abdomen, Muay Thai fighters, and this happens thousands of times and people don't get these kind of injuries. So there's that issue. Also, I think that because aggravated assault with a deadly weapon or aggravated assault, serious bodily injury is a result oriented offense, someone could use a punch, which I don't believe is generally deadly force. A punch would normally be just force. But if the person were to fall down a flight of stairs because of that, they could receive serious bodily injury, even though the force only used was force.
Okay, so what I can tell you is, I think what should go on for my interpretation of the statute and the case law, I think deadly force should be the correct from section 9932. But I'll listen to everybody.
Yeah.
We'll put it all on the record, but
Okay.
based upon my review of the case law and based upon everything that I'm viewing, it doesn't seem that just use of force applies in this case, based upon what I'm reading.
Is it possible to charge both, Your Honor?
No, I don't think that's appropriate.
Okay.
All right. All right, so we'll go on the record. I'll hear your arguments. If you can have your client come in, please. Oh, Norma,
Yes, ma'am.
the charge is going to have to, some things are going to have to be added to the charge, so it's going to be a little bit.
It's on the phone. I'll wait.
Responsible. He thinks the guy did it. Just get it out.
Is the client here? All right. All right. Okay. That's fine. All right, who's here on Christopher Mariscal?
I'm here, Your Honor. Mr. Mariscal is here as well.
All right, if you have him come forward, please.
Yes, Judge.
And just let me sign into Odyssey. Hello. Thank you for dressing appropriately for court, but you always do. I really appreciate that. Sometimes people don't understand. And I always say they don't understand because they haven't been to court. People always think these are, rules that I'm making up, but in court, there's a standard of dress you have to have. I would always tell my clients, it's okay if you have jeans, but don't do the ripped jeans. If you do some khakis, and I always tell them, we can do a t-shirt, just make sure it has sleeves. I used to tell my clients, dress as though you're going to church. And then one of my clients came dressed as they're going to church, and I'm like, oh my gosh, this is not the way we do in Louisiana. All right, let me see. I can get my Odyssey to behave well. All right, so today is plea deadline date. Do you have all of the discovery?
We do have all of the discovery, Your Honor.
All right, so does your client wish to have a jury trial?
Well, I don't want to run afoul of any of the court's admonishments about agreements and things
Mhm.
like that. I was going to ask for 30 more days to confer with the state. There's some mitigation that I'm putting together. We have a plea offer, we have all the discovery. It's just, I wasn't going to execute it today unless we absolutely had to. I'm still conferring with the state a bit. And
All
I'm
right,
optimistic.
I will give you 20 days.
That would be great. Thank you, Judge.
All right, Ms. Ferguson, I need a 20-day reset. And this will be your final plea deadline date.
Thank you, Judge.
You're welcome.
Okay.
All right, June 2nd. Yes,
May I have later in that week, Your Honor?
June 5th.
Yes, thank you, Judge.
All right. So this is coming back on June 5th.
Thank you.
And that will be your final plea deadline date. All right, you can have a seat. Once you sign the reset form, you're excused. You're welcome.
Judge, depending on the age and gender of the church attendee, you might end up with a big hat.
Yeah, that's true. All right, who's found Gerardo Herrera? All right, Deputy Laura,
Yes, Judge.
could you make an announcement for Gerardo Marino Herrera, please? Yes. Yeah, I just got kicked out of Odyssey. They were like, you're not welcome. Maybe that means I can go home.
He's not out there, Your Honor.
All right, court is calling 2020 CR 0012W State versus Gerardo Marino Herrera. Can I have parties announced?
Megan Galloway for the state.
Albert Chidas for Mr.
All right, this case was scheduled today at 9 a.m. It is now 9:16 a.m. Deputy Laura, did you make an announcement for the defendant?
Yes, Your Honor, I did. He is not out there.
All right, and when the court called docket, the defendant was not in the courtroom, and the defendant still is not present in the courtroom. Defense, have you had contact with your client?
I did back, about a couple of days back, but I haven't had any contact with him this morning.
All right. Court is going to issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. You're welcome.
Judge, I'm not getting any audio. I'm trying to figure this out. Now all of a sudden.
Excuse me, at 7 o'clock Friday night. I had to give him a credit card. But luckily the coordinator was taking the. And then they did start. Skip this, so did you. Like, I hate power more. No, I hate. The whole thing. That's what they're fighting. I'm pretty sure. I wouldn't surprise you.
Good morning.
My jury's still like once in the court. Are we gonna be able to?
All right, Cindy.
No.
Are you ready to go on record with our argument?
I'm gonna tape this down so it doesn't move on me.
Okay.
Does she have family violence in here? Or in the hallways?
I have no idea.
The red counsel was looking for him.
Okay.
I thought he was in the jury's waiting room.
All right, Cindy, are you ready?
Gonna have to go.
Okay.
Go ahead.
All right, the court is calling 2024 CR 2338B State versus Mariano Rendon. Can I have parties announce for the record?
Gouty and Jason Garahan for the state.
Larry Bloomquist for the defense. I'm here with my client, Mariano Rendon.
All right. So we're here on the charge conference and state it's the court's understanding that you are not going to ask for the law of parties.
That's correct, Your Honor.
All right, and defense. There are 2 points you wanted added to the charge, is that correct?
Yes, Your Honor.
All right, what are you requesting?
So I'm actually requesting a couple different things. So one, I'm asking that we continue to keep the law of both 9.31 and 9.32 in the charge. I believe that that's how we had it yesterday. I believe that's appropriate because in this particular case, the force used was a knee strike, and I believe that that is usually just force, although and the jury could believe or disbelieve that it caused serious bodily injury. There's testimony that other things can cause that. So, you know, the jury could easily find that he used force and that no serious bodily injury was created. And so I believe that it's appropriate for the court to charge on both 9.31 self-defense, including force, and 9.32 self-defense, including deadly force. I think it's cleaner if the court charges it both ways. In addition.
All right, just 1 second. Let's address that first issue.
Yes.
State.
So we have no objection regarding the 9.32 deadly force instruction. The state is objecting to the 9.31 non-deadly force instruction, and the defendant is not entitled to an instruction regarding non-deadly force because the victim sustained serious bodily injury in this case. We've had witnesses testify to that, and the cases that support that position are Farrell v. State. The site is 55 Southwestern 586. Denman v. State, site 193 Southwestern 129. And then Wood v. State, site 271 Southwestern 329. And specifically in Farrell v. State, the holding was that the court did not err in refusing to give an instruction under 9.31 when the force used caused serious bodily injury. And then in Denman v. State, the holding in that case is that the reviewing court accept the end result of the act, and if the facts are that the victim dies or suffers serious bodily injury, then by definition, the force used is deadly and the appropriate instruction would be under.
I would just point out that in this particular case, that it wasn't where we had somebody who was obviously received serious bodily injury on the scene. I mean, they actually walked away, left the scene. So I think there's some real argument about whether actually this incident caused serious bodily injury. And that's, I think, a fact for the jury to decide. And I think also, and because of that, because the jury could find that his actions did not cause deadly force. It's not like a stab wound or a gunshot. It's a thing that happened 2 days later when he reports to the doctor. And we talked about, the doctor testified about all these other things that could cause ruptured intestines. So based on that, I believe that a jury could find that the use of force was just force.
All right. So defense, your instruction under 9.31 will be denied. The instruction given under 9.32 will be allowed. All right, and next, what's your next request?
I filed with the court, I gotta sign those, but I filed with the court our requested jury instructions and our requested jury instructions on the presumption. There's evidence in this case.
All right, and so my understanding is that the state is not objecting to presumption. So that will be in.
That's the only other issue I have.
All right, so
Other than that, I'm satisfied.
all right, so the presumption will be in, and then what will be included then is the full definition for robbery. All right, is there anything else?
No, you're.
All right, I'll have the charge writer send us that information. And if there's no objection, I'm going to send her an email to what you all both have agreed on so that she can add it to the charge.
That's fine.
All
The other thing, just for clarification, for my clarification, we discussed whether that we were going to give 2 paragraphs, one on self-defense, one on just third party did the court decide on that?
Well, did you want to argue
Yeah,
the defense of third party?
Well, obviously, I think defense of third party.
I'm sorry, I'm sorry, excuse me, the defense of third party for the court's review of the evidence, that should be in there.
Of course.
So if you can address your request
Yeah.
for self-defense.
So why I'm also asking for the well, obviously, I think the self-defense instruction has to be included because the third party defense refers back to it. Because it says that basically has to be authorized under 9.32 to use the force. I think that should be in the instruction regardless. And then the second thing is that in this particular case, there was this melee that occurred. There was multiple people attacking multiple people. And my client did have injuries from that. So almost like a lot of parties on going the opposite side. My client had a scratch on his neck and was assaulted during the commission of this melee. And so therefore, I think he's entitled to a self-defense instruction based on that.
All right.
We did have evidence of that assault by the photographs of the injury to his neck.
All right, and state with regards to the defense's request for self-defense.
So regarding it being charged, I guess I would just object to the application paragraph of it. I agree that it should be included in the defense of the third persons, but I would just reiterate that.
All right, any final argument?
Yeah, I mean, I think the fact that he was actually injured during the assault and he did testify about being assaulted by Esperanza Garza, who was assisting Pablo Rodriguez in the assault that occurred on the security officer. I believe that that's sufficient for us to get an application period on both.
All right, the court will allow the defense's request for self-defense in the charge. All right, is there anything else from either side with regards to the charge?
No, Your Honor.
No, Judge.
All right. How much time are you all requesting? We can go off the record.
I think about 40 minutes, Your Honor. It looks skeptical.
20 minutes,
Let's split this and call it 30 minutes. Your
19 minutes.
Honor. I'm obviously gambling with the house.
All right, so what I'll do is I'll give each side 20 minutes. If y'all end up going over a little bit, I won't interrupt you. Does anyone request a time announcement?
5 minutes.
Okay. There's another judge who would have given you all 5 minutes for closing argument. All right, everyone, because we're waiting for the charge, if you have someone who's on bond and you all have conferred and you're ready, you may approach. Hello, hi, who do you have? Oh, okay. All right, thank you. Okay. All right. Okay, all right, thank you. No problem. Alex Russell Bacon. Alex Russell Bacon. David Warren Brown. David Warren Brown. Alexandra Hernandez Mejia. Alexandra Hernandez Mejia.
May I be excused to go to another court?
Yes.
That's mine.
Yeah, okay.
I'll come back and make sure.
All right, thank you. Bradley Tyler Galan.
Council's President, Your Honor, I believe Mr. Galan was allowed appearance on Zoom tonight.
All right, and he hasn't, let me see if he's shown.
I don't know if we've provided him the Zoom.
Yeah, he's not here yet. If you'll let them know. Could I see the following? Arturo Villanueva? And State, are you ready to proceed on restitution on Villanueva? It's a failure to stop and render aid.
Let me see where.
Okay, sure. Oh, thank you. All right, so defense, Daniel Vela.
Judge, I'm here.
All right, have you had a chance to speak with the state on the restitution?
No, I have not, Your Honor. I would love to.
All right, state, Mr. Vela, I'm gonna put you in a waiting room. And if you can either call him or if you want to appear on Zoom to speak with Mr. Vela, it's concerning Arturo Villanueva.
Yes, Judge.
All right, I'll put you in the waiting room with, and your client in a waiting room, and the state will speak to you. Okay.
He called last week. He showed up, I guess they ran this morning and he showed up, so I didn't know. Previously scheduled. Okay, I just popped in and double check. Yes, ma'am, he applied. Okay. That's. Check. And I brought to his attention last week. The paperwork, but then put the count one. So it's just count one. I combined the two paragraphs. Okay. But I told him the judicial admission in the plea was is accurate. It
Okay.
reflects the chart. Just the plea agreement says one.
Okay.
It's just one.
Thank you.
Y'all need me just like.
Yes, thank you.
It was my right.
Okay.
Yeah, that's right.
Cindy, do you need IT called down?
I might. It's just.
Could you call IT down, please? Thank you.
Yes. Cindy, is it your audio from your equipment?
It's my audio. Well. It's working now. I just shut everything down.
Oh, Norma, you can cancel it.
That's what. Yeah. I'm not touching anything, no, just gonna. Scoot back.
You got it working.
So. I don't wrap around the drivetrain because it's taking a photo.
Oh, yeah.
Jenna, could you ask Yaya to pull out copies of the jury charge? Yes. And I'll need 6 copies. Okay. Thank you. Hello. Good morning. All right. Did you ask him to pull the file? Did you confer with the state?
Well, that's what I'm doing right now, but he has a response. It involves reaching out to witnesses.
All right.
So we.
Yes.
Brooks.
Which case is this?
Gregory Jennings.
All right, can I see the file on Gregory Jennings, please? All right, how are you doing? Oh, I'm doing okay. Thank you so much for dressing appropriately for court. So my understanding is the state has filed a dismissal in your case for insufficient evidence. So I'm going to sign it. Enjoy the rest of your day. All right, you're welcome.
Thank you, Judge. May we be excused?
Yes. Cheers. Oh, okay. Deputy Laura, all the jurors here? All right, thank you. All right, Zoe Brooks. All right, Yaya should be printing out the jury charge and then we'll start right up. All right, you need to make sure that you're on time for court, you understand? And no gum chewing. All right, so state, were you able to attend an offer?
No, Judge, it's sort of a preliminary review. It's 3 different cases. It's
Okay.
all ag robberies, but they're all different ones.
Ah,
So we do need to get we've got a hold of 1 victim, just not the other 2 at this moment.
all right, so defense. State is currently in jury trial. Normally, I don't set this past 30 days, but do you have any objection to a 45-day reset?
Judge, I wouldn't object to 90 days.
All right, 44 days.
I heard the negotiations earlier. I'm gonna stop where I'm at.
Okay. Norma, if I can have a 45-day reset, please.
26.
All right, is June 26th good for everyone?
Should have said yes.
Yes.
All right, so we'll see you back here on June 26th at 9 a.m. All right, thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused. You're
Thank you,
welcome.
Judge.
You're welcome.
What day of the week is the 26th?
Thursday.
Here you go, Mick.
I conferred with Mr. Vela on Mr. Villanueva.
All right. And if only he were here now, he's not. All right, Mr. Villanueva,
Yes.
if you can call your attorney and tell him he's needed back in the Zoom.
Okay.
All right, thank you.
Will you pardon me for a moment, Judge?
Sure. All right, Alex Russell Bacon.
Here, Judge.
All right, if you'll come forward, please. All right, so you need to make sure you're on time for court, okay?
I'm trying to, throughout the last over here, to go around, part of that day.
All right, so court starts at 9 a.m., all right? All right, so we're gonna recall your case. And Norma, recall this case for, are you employed?
It's basically got, like, last Monday.
Okay, so we're gonna recall this for Thursday, May 15th, okay? Once you sign the reset form, you're excused. All right, thank you. Norma, what case is that on? It doesn't tell me anything.
That's the long. I mean, that's the bacon case. The email,
Yes.
that's the one with the bacon,
Okay. All right. Thank you.
the bacon case.
All right. Who is here on Bradley Galvan?
Mr. Galan should be logged in on Zoom.
All right. So we have Mr. Galvan. You need to start your video. Thank you. All right. So we have a possession case, and then we have a taken certain wildlife case. And the last time we were here with the wildlife case, there was some issue about an appellate ruling.
That's my understanding of the history of the case, Your Honor. However, Mr. Galan recently hired our firm this past week.
Mhm.
We just entered appearance on Friday.
Mhm.
So we haven't had the opportunity to receive, download, and review all the discovery completion. I did have a chance this morning to review the state's file
Mhm.
for the written discovery, but there is still some issues from the history of the case regarding that appellate issue. And I need to follow up with the state on some other discovery requests that were done prior to our entering the case.
All right, this has been going on for over a year now with us awaiting the appellate ruling. Ms. Ferguson,
Yes, sir.
they're gonna need a jury trial date, so if you'll confer with Ms. Ferguson on a jury trial date.
Yes, ma'am.
All right, and then once you have the date, let the court know.
Yes, Your Honor.
All right, thank you. All right, Mr. Galan, just give us a moment. Yes.
Judge, prior to setting it for a trial, just because I haven't had the chance to confer with the state about any sort of resolutions, we possibly have a plea deadline prior to.
All right, it'll be trial date and plea deadline date, and if you're all gonna enter a plea, it needs to be done before the jury trial date.
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
You're welcome. All right, and we're still awaiting the attorney. And I'm
Yes,
gonna go in, and I'm gonna go in the back right quick and check to see if the documents have been printed off.
I'll check.
Yes,
Yep,
thank
I'll
you.
check. Oh, July 22nd.
All right. So July 22nd is gonna be your jury trial date.
Yes, Your Honor.
All right, thank you.
And I'll make sure to get as much as I can.
All right.
Thank you.
All right, thank you. You're gonna need to be in court on July 22nd for your jury trial.
Yes,
All right, thank you for dressing appropriately for court.
yes, ma'am. Hey.
All right, you too.
I understand.
All right, I cannot complain. It's a beautiful day.
Say about loud, I mean.
Oh, oh, no. Hello, morning.
Conferred. That made us.
Yes, to pull the file.
I'm sorry.
That's okay.
De Hoyos.
Says-
All right, Jonathan De Hoyos, come forward. And counsel, you received all discovery,
We have received discovery on this matter, Your Honor.
and you said an offer has been tendered.
It has been relayed to us, Judge.
How old are you? All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date.
Judge,
You're welcome.
may we be excused?
Oh, you haven't got your date yet. All right, so we're gonna come back on June 10th. On June 10th, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date is jury trial date. You understand? All right, and thank you for dressing appropriately for court. Just have a seat and your attorney will bring you the reset form. Thank you. All right, so we're here on Arturo Villanueva.
Yes, Judge.
Oh, thank you so much.
Make sure it's a good phone number because they're gonna call you on that.
So have you all,
Okay, now this one's an email address. Make sure this is the
Agreement.
email address.
restitution?
We have not, Judge.
All right, are y'all ready to proceed?
We are not, Judge. The request that the complainant will make, I suspect, will require additional documentation.
The address you gave, 73191.
All right, defense, they're asking for 2 weeks to provide documentation. Any objection?
Judge, I mean, my client would like to get this issue resolved. I mean, I'd like to go forward today.
All right, so Mr. Villanueva, what I can tell you is this is the last reset that the court is going to allow for restitution. State if you're not prepared with the restitution hearing at this next court date, then there's not going to be any restitution.
I understand.
Ms. Ferguson, I need a 2-week reset for a restitution hearing, and Mr. Villanueva, you can appear by Zoom.
Thank you, Your Honor.
I'm sorry, when? All right, so it's going to be May 27th. And Mr. Villanueva, I'll notate that there will be no more granting of state's requests for continuance as it relates to restitution, okay?
That's why it takes a couple days.
All right, thank you. Have a good day. Thank you for dressing appropriately for court. All right, you may be excused. And Bashan, that will be the last restitution we will have on that case. All right. We're on the record in 2024 CR 2338B State versus Mariano Rendon. Can I have parties announced for the record?
Megan Galloway and Jason Garrett from the state.
Larry Bloomquist for the defense, and I'm here with Mariano Rendon, the defendant.
All right, so the court received the final charge. Have both parties received the final charge, and is there any objection?
Judge, C objects to request the self-defense or the 9.31 instruction, but other than that, we're satisfied.
All right, are both parties ready to proceed with closing?
Defense ready, Your Honor.
All right, so each side you'll have 20 minutes. I'll give you a 5-minute warning. Is there any equipment that needs to be set up?
Yeah.
Yes. Sometimes it works, sometimes it doesn't.
Yeah, we're good to go.
Okay, awesome. All right, everyone, Y'all need to make sure your cell phones are off. There's nothing worse when you're in your groove, you're doing your closing argument, and somebody's phones goes off. So let's not do that. We're ready.
All rise for the jury.
Everyone, please be seated. All right, ladies and gentlemen, thank you so much for your patience. As you can see, there are other people in the courtroom today. It's unrelated to this case. Each party is going to have a chance to do their closing arguments to you. I'm going to read you the jury charge, or what's called the charge of the court. You do not have to memorize it. You will have the original with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant Mariano Rendon stands charged by indictment with the offense of aggravated assault alleged to have been committed on or about the 20th day of August 2023 in Bexar County, Texas. To this charge, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the person intentionally, knowingly, or recklessly causes serious bodily injury to another. 2, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards the substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, justification defense of self-defense in defense of a third person. Self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he defense of self-defense in defense of a third person. Self-defense. You are instructed that it is a defense to this.
I think it is.
All right, who's here on Stefan? Oh, he's by Zoom, Norma. Can you make sure that Juan Carlos zooms in? Who is here on Guillermo Mendoza?
I'm here, Your Honor.
Good afternoon, Judge. Good afternoon. How's it going?
Good, how are you?
Oh, I'm doing okay. I cannot complain. Court is calling 2025 CR 002-746 State versus Guillermo Mendoza III. Can I have parties announced?
Andrew here, State.
I'm on docket for Guillermo Mendoza III, Your Honor.
And are you Mr. Mendoza?
Yes, Your Honor.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery probation. This is an application on a DWI. Mr. Mendoza, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Mendoza, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with driving while intoxicated third or more is a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to accept your plea. If for any reason the court does not accept your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mendoza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone has promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your
Are you a U.S. citizen?
Honor. Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. State recommends community supervision. There's to be restitution of $60 to Texas DPS and ignition interlock for half the term. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a top evaluation, 10 days in the Bexar County Jail as a condition, 200 hours of community service restitution, DWI intervention, and VIP. Did you understand those were recommendations from the state and the
Yes.
court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objection, Your Honor.
All right, state, with regards to the 10 days in the Bexar County Jail, any objection to that time being served on GPS? All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He just wanted me to let the court know that he is motivated to comply. And he also wanted me to provide this to the court. He's showing he has proof of employment and that he does have a strong support system. His wife's actually here in the 3rd row, and that's just a photo of him with his family. So we just offer that to show that he wants to be a success on probation.
Okay. So, Mr. Mendoza, the court has in its receipt a second violation for high brack reading. So what's going on with you? Now's the time to get the help that you need for any type of alcohol issues you may have. So what's that about?
Sorry about that, and
Well, I mean, why are you drinking when you're on bond and you're not supposed to drink?
no excuse.
I asked him the question directly because we actually visited on this weekend, and he's been very upfront. He is an alcoholic. He does want treatment, and I think that's a big step. He's here pleading to the court, and he's the sole provider for his family. So when he does this, he not only hurts himself, but he hurts his children at home.
So why do you think you drink? On this day, with regards to the violation report, they had a high brack reading on May 5th. So why do you drink when you know you're not supposed to? What was going on that day? Do you even remember? All right. So here's the thing. This is not just on DWIs, but doubly on DWIs. You're not allowed to drink alcohol at all. That means that whether you're driving or not, you're not allowed to drink alcohol. Do you understand? So it's obvious to the court that you need some help. So we're going to get you some help. If you fail to complete this probation successfully, you're looking at potentially 6 years in the prison. So if you're not going to stop drinking for yourself, then you need to start thinking about your family and thinking about, is that next drink worth potentially 6 years in the prison? But I'm going to give you the help you need with regards to getting control and maintaining your sobriety. All right, this is what the court is going to do. The court is going to sentence you to 6 years in the prison, suspended and probated for 5 years. There's a $2,000 fine that will be probated. Proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. The state is asking for ignition interlock for half the term. I know that's part of your plea bargain agreement. I think he may need to be on ignition interlock for longer than that.
We would defer to the court on that matter.
All right, so what I'll do, probation, he's going to be on ignition interlock till further notice. Do not approach the court at least until half the term has expired if you want that removed. You understand?
Yes, sir.
All right, so that's the ignition interlock till further notice. $60 restitution to Texas DPS for testing. Regular reporting by Zoom or in person. Regular random UAs. He has a choice. He can do 10 days in the Bexar County Jail. That would start today. Or he can be on GPS partial, and that will be for work only, and it will be 20 days.
We're requesting GPS in light of his employment, Your Honor.
All right, so there'll be partial GPS for employment only. And that will be for 20 days. Are you able to afford GPS?
Yes, the ankle monitor.
Okay.
Yeah, you're working.
Oh, yes, sir.
All right, there'll be a 2-year license suspension. 200 hours of community service restitution. That will be waived once he completes parenting classes. There should be 120 sober meetings in 120 days. TAP evaluation out of custody. Follow TAP recommendations. And we'll do a referral to felony drug court, DWI intervention course, DWI education course, victim impact panel live, field visits 1 time per month until further notice. And how many vehicles are at your home?
It's why I own one.
All right, but how many vehicles are at your home?
Does your wife also have a vehicle or do you have other vehicles?
Yes.
How many total do you have?
2.
All right, there's going to be ignition interlock on all vehicles he has access to. So if it's at your house, that means you have access to it. Now, with regards to the ignition interlock for half the term and having it on all vehicles, you can come to me before half the term if there are some financial issues going on with regards to having it on 2 vehicles.
Thank you, Jerry.
All right, and I'm putting you on the ignition interlock on 2 vehicles because you have a drinking problem and ignition interlock is not stopping it. So this way, at least you won't be able to go from one vehicle to the next vehicle. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, yeah.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. You have children, maybe grandchildren, right? If somebody, even you, if you're driving while intoxicated, it could have been your grandchildren or your children out there and you hit them. And nobody, I don't know anyone in defense, help me if you've ever heard of anyone who's charged with DWI, who hit someone, injures someone, or kills someone, who says, oh, you know what? When I was going out to drink, in my mind, I was like, hey, I want to get intoxicated and kill someone. Nobody ever says that. They always come to court, they cry, they didn't mean to do it. But at the end of the day, you've injured somebody or taken their life. And I don't want that to happen for you, okay?
Yes, sir.
Probation is, in this court, communication is key with probation. If you have an issue with something that they're asking of you, if you can't get in touch with probation, you can always come back to the court, okay?
Yes, sir.
All right, good luck to you, and thank you for dressing appropriately for court.
Thank you.
Welcome.
May I be excused, Your Honor?
Yes.
Thank you.
Stephen Palacios Cruz, if you'll come forward, please. Hello.
How you doing?
All right, how are you doing?
Good.
All right, court is calling 2025 CR 003592. Excuse me, in the back, if you all will ask the deputy to move you to the other end, please. Court is calling 2025 CR 003592, State of Texas versus Stephen Palacios Cruz. Can I have parties announced? State?
Andrew Harrison.
Defense?
Juan Carlos Hernandez for Mr. Stefan Palacio Cruz.
And are you Mr. Palacios Cruz?
Yes, sir.
All right, State, do you have any objection to the attorney appearing by Zoom?
Okay.
And Mr. Cruz, do you have any objection to your attorney appearing by Zoom? Counsel, have you received all the discovery from the state and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cruz, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Off the record for a moment. Yeah. I think this personal data sheet goes to Bashan. All right, we're back on the record. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No objections, Your Honor.
All right, Mr. Cruz, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand in count 2 of the indictment, you're charged with possession of a controlled substance penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe.
Mr. Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, state is proceeding on count 2. They're recommending deferred adjudication. This is run concurrent with County Court Cause number 730915. Did you understand that to be the plea?
Yes.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, there has not, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers exhibit 1 and attachment.
No objections, Your Honor.
All right, Mr. State, you may be excused. Mr. Cruz, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, Your Honor.
All right, anything you wish to say on behalf of your client?
Just briefly, Your Honor, Stefan has just turned 25 this month. He's got no prior convictions. He is extremely embarrassed, actually, with his family, that he even did such an immature decision and poor choice to get involved in this. He has now really wanting he got a job at Cheesecake Factory at North Star Mall, and he's looking into getting enrolled with the Culinary Arts Institute at the Pearl. He wants to become a chef, and he wants to change his life around and be there for his daughter.
All right, if you're drug tested today, what are the results going to be?
Negative.
When's the last time you used?
It's been over half a year already.
Okay. And what's your relationship with the co-defendant in this case?
My daughter's
Mother.
we're not together anymore. It's been over 3-4 months since I really talked to her already.
All right. All right, this is what the court is gonna do. The court is gonna sentence you to 6 years deferred adjudication. This is run concurrent with County Court Cause number 7300915. Regular reporting by Zoom or in person, regular random UAs, a referral to felony drug court and a TAP evaluation out of custody, follow TAP recommendations. There's to be no unsupervised contact with minors. Field visits 1 time per month until further notice. 200 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, 100 hours will be deemed satisfied. The remaining 100 hours will be deemed satisfied if he obtains some type of higher level education or some trade school certificate. I'm not ordering that part. I am ordering the parenting classes.
Yes, ma'am.
All right, there's to be no contact with Alexandra Hernandez Mejia, 60 sober meetings in 60 days. Restitution to SAPD for testing. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
I would like to say just a couple of concerns that I have.
Sure.
Stefan is no longer with Alex, so their relationship's not together, but they do have a 5-year-old daughter. And with the no contact with her, that makes it so difficult to try to raise a child, pick them up from school. If there's no contact, and I would hate for him not to be able to be successful on probation if he has such an obstacle preventing them from being a family, even if it's distant family, just there to pick up the child. I know your concern is that you don't want them hanging out anymore because you don't think they're good for
Oh,
each.
no, let me explain to you, counsel. The co-defendant was just here. The co-defendant is still using drugs.
Okay.
And so they're having contact. If your client is truly clean and sober, he's going to be tested to find out if he's truly clean and sober. He can't be around someone who's not clean and sober because that causes everything to fall apart. And the other thing is, I'm not allowing the co-defendant in this case to have any unsupervised contact with the child because in actuality, she's not raising the child. It's the grandparent. So if he has some kind of child exchange, then it will be through the maternal grandparents anyway, because the co-defendant is still not clean and sober.
Okay, I got you. And then with regards to if Stefan continues to stay clean and not use drugs, at what point will he be able to be the little girl's father without any supervision?
Oh, just come back. And I would say come back after I receive information on the TAP evaluation, what they're recommending. And if he's back in 6 months and there are no problems, I'll strongly consider removing the no unsupervised contact.
Okay, thank you, Your Honor.
You're welcome. Is there anything else that you need from the court?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, then you can always come back to court. Do you understand?
Yes.
And I'm going to explain to you about children. Children look up to their parents. If you have no intention of maintaining your sobriety and you're just going to be one of those parents who makes promises and don't show up, then don't do that because that breaks a child's heart. You know, you need to decide what type of parent you're going to be. Are you the one that just comes over for fun and games and then leave the hard work to somebody else or not? You got to make those decisions. You understand?
Yes.
All right. Good luck to you. And thank you for dressing appropriately for court.
Yes.
All right. Thanks, counsel.
Thank you, Judge.
Welcome. All right. So, Vashawn, County Connection is having a feral hog management. What is that about? Are we managing feral hogs? Isn't that what makes them feral? They're not being managed? I don't know. You know, on Ingram, they always have a bunch of feral hogs running around. They say feral hogs are very dangerous. I don't know. All right. Hi, so on this case, if you can discuss. All right, Jesse Garza, is he in custody?
Yes.
All right, recall that state Jesse Garza is being recalled for tomorrow. Defense counsel said he had no notice through Odyssey. Who's here on Leslie O'Bannon?
I'm Your Honor.
Yes.
I apologize for no tie. I
Mhm.
had her on Thursday's docket.
Okay. Is she
We are
here?
Yeah, she's there.
Oh, where is she?
Box. Right there.
Oh, yes.
We referred her to the mental health docket and
Mhm.
we have not had a reply from them yet. That was
All
2
right,
weeks ago.
Norma, can you check and see what's the referral on the mental health docket?
Sent over in April.
Hi. Hi.
Judge, I would like to say on my behalf, I don't need to go to that docket. I'm here in court and I'd like to be out today.
All right, so here's the thing. I'm gonna allow you to discuss things with your
He
attorney.
hasn't even spoken to me.
Well, here's the thing. He's here, you're here, so he can speak to you, okay? All right.
I'd like to do that.
All right, so if you'll, here's the thing. Talk to your attorney
I've been here.
and then we can come back up.
Okay.
I have family
Thank you.
that want me out too.
Lost my prosecutor.
All right. State, Jalen Ross is being recalled for tomorrow at the request of defense. And it is family violence. All right, thank you.
Do you want him dressed for tomorrow?
Yes. All right, who is here on Efren Soto? And after that, we're going to take up the motion to suppress. Court is calling 2025 CR 0000850 State versus Efren Soto. Hello. Hi. All right, how are you doing?
Doing great.
It's always nice when people ask how you're doing, you know? All right, counsel, have you received all discovery?
I have.
Did you review it with your client?
Yes. Yes.
Court will find that the state is in compliance with discovery. Is there an application in this?
Yes.
Oh, you know what? I did not fill out an application.
All right, if you could grab that for me,
Okay,
please.
okay.
All right, you're applying for probation? All right, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? Phyllis, you read, okay. State, are you proceeding on the indictment as presented?
Yes.
Okay. Mr. Soto, did you review court, excuse me, off the record? Deputy Laura, can you move up to the other end? Mr. Soto, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with theft of property, 2,500 to 30,000 as a state jail felony?
Yes.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Soto, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision. This is run concurrent with 2021 CR 11632. There's to be restitution of $10,800 to Mr. Brooks to be paid within the first 60 days of probation. Did you understand that to be the plea? Defense, is that the plea?
It is.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours community service restitution, no contact with the complainant, and 10 days in the Bexar County Jail as a condition. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State exhibit number 1.
No objections.
All right, state, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. What I'm going to do, my understanding is that you're going to have the $10,800 in 60 days. All right, I'm going to recall this for 60 days for sentencing.
And Your Honor, we would like a PSI as well during that time.
All right. Norma, I need a 60-day reset. All right, we'll come back on July 10th for sentencing. And then probation, this will be a PSI and TAP evaluation. All right, is there anything else?
That's it. Thank you.
Yes.
I had to take a course before today.
No.
I believe that was last time.
I think.
Oh, it may be related to his motion to revoke. Is that correct?
I think it's, yeah.
It was that too.
And he's already taken that.
And I already took the course and I have 2 of them.
Oh, so what you'll need to do is speak to probation because those are conditions on that case.
Okay, so I already sent it to her.
Okay.
To the probation officers.
Okay.
I just want to make sure.
Sure, no problem.
Thank you.
Thank you.
God bless you.
Oh, God bless you too. And Vashawn,
Yes, Judge.
on that, with regards to the restitution, Ms. Bill, you don't give it to probation if you'll have the complainant's name or the cashier's check, the complainant's name, and the state will get it to them. If you send it through probation, it's gonna get lost in the system.
So who do I, okay, so when I have payments, who can
You'll make it out to the complainant, let the
directly
state
to
know.
Mr. Bruce?
Yes, let the state know, and the state will have the advocate, whoever it is, where, let you know where it needs to go.
So he came with a partial payment today, but
He does he have a partial payment?
he has a partial.
All right, state. He has a partial payment today for Mr. Brooks.
This, you know, didn't mention that.
So it's best that it not go through probation, so maybe you can call your advocate down
Oh, sure.
to make sure.
Like,
Yes.
I can do it up for restitution.
All
I
right.
mean, it would have to be in the form of a cashier's check.
It is.
Oh, it is?
Well, not cashier's check, it's
It's a money order.
Money
Yes.
order, I think that money order should work
Yes.
too.
Okay.
As long as it's made out to.
Well,
Mr.
it
Brooks.
has not, it's not
Okay.
filled out yet.
Okay.
Okay, all right, just give that to them.
Okay.
All right, thank you.
Okay.
Thank you.
Okay, thank you. All right, who's here on Jack Albert Evans?
President, Your Honor,
Are y'all ready to proceed with the motion to suppress?
defense counsel's ready.
All right, court is calling 2025 CR 0027769 State versus Jack Albert Evans Jr. Could I have parties announced for the record?
Renee Munoz on behalf of Mr. Evans.
And are you Mr. Evans? All right, the defense has requested a motion to suppress hearing. And is this a case involving a warrant or not?
No, Your Honor.
Warrantless detention.
All right, state, you may proceed.
Officer McFadden.
All right, Officer McFadden.
Your Honor, may I attend to the court case law, which I attended to the state as well? Regarding the law surrounding some of these issues.
Of course. Oh, is this gonna be long? Hearing?
The one witness, correct?
Oh, so he can either sit there or he can stand here, and I'll need you to move over there, sir.
Right here.
Hello. Hi, all right. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Officer Zachary McFadden, badge number 1507.
All right, in just one moment. Here you are, don't hold it.
Thank you. Bad habit.
No problem. And you know, as children, my grandmother would always say, don't swallow it, it's gonna ruin your intestines. Don't know if that's true or not, but we don't. All right. State your witness.
Officer, considering your desire, fair to say that you're a sanitary police department officer.
Dave.
You're a sanitary police department officer.
Yes, sir.
And were you for the next capacity of the
Yes, sir.
On that day, were you not going?
Yes, sir.
What shift did you?
South Patrol B shift.
What is the shift?
B shift is from 13:30 hours to 21:30 hours.
In normal time. how is it?
Sorry. 1:30 PM to 9:30 PM.
And you said South Patrol, correct?
Yes, sir.
What is South Patrol?
South Patrol, the city is divided up into north, south, east, west, central, downtown, and Cruz. South covers Highway 90 and below out to I-37, a large area.
And you're responsible for control over that entire area?
No, sir, it's divided up into sections. We have 3 sections, and I was assigned to the one side. So I believe the area this is in is Commercial Avenue area. It's considered the one side.
And what characteristics does the one side have?
Okay, the one side is, there's a lot of known drug trafficking areas. Very common for persons on bicycles to be pulling narcotics. Most common on South is methamphetamine. Second to that is going to be heroin. And
And do you know this from your personal experience on patrol in this area?
yes, sir.
Have you experienced instances in which people on bikes have been signaled to stop and have refused to do so?
Yes, sir, many instances.
Does that happen more often during the day or at night?
More often at night.
Is there a particular reason for that based off of your experience?
I think in a general sense, from a human perspective, anyone that is concealing narcotics on them don't want to be caught by the police. And on a bicycle, there's a sense of I'm already moving, and I think I could probably get places where vehicles can't, off of roadways, into people's yards, into ditches. They go from there.
Now, during your patrol, were you equipped with a body worn camera recording device?
Yes, sir.
And was that recording device operating correctly?
Yes, sir.
How did you know?
I knew because there's a button on the front, tap it twice, and then we look down and see a red flashing light. If it's flashing red and it vibrates, then I know it's active.
January 12th, 2025, approximately 7:11, and you observed a person riding a bicycle on the side.
Yes, sir.
And did you, what else did you observe about this bicycle?
The time of day was after dark. The individual was wearing dark clothing. He was on a bicycle on a city sidewalk, which is a city ordinance violation. And there was no proper lighting equipment on the bicycle. So it's not just a ordinance violation, but also a safety hazard.
What lighting equipment should have been on the bicycle?
Should have a headlight and a tail light, similar to a regular road traffic vehicle.
And did this bicycle have a headlight on it?
No, sir.
Now, were you partnered with any other personnel?
Yes, Officer Brent Vermeulen.
And what did you and Vermeulen do in response to what you observed?
After we observed the ordinance violation in the specific area, the individual was coming from a known drug pickup spot, a gas station. We initiated our emergency lights, initiated a traffic stop with Officer Vermeulen in the lead. I was in the rear. The individual did not come to a stop immediately. There's approximately one city block. During that time, based off of our experience, I maneuvered to be in front of the individual, anticipating that he was probably going to run based off of the time of day, our experience, and his immediate behavior when the lights came on.
What is Mark State's incident? Do you recognize that?
Yes, sir.
What is?
This is a recording of my body worn camera on the day of the incident.
And how do you recognize it?
I reviewed it prior to this testimony and signed and dated it.
Does that recording have any edits or changes to it from what you experienced on January 11th, 2025?
No, sir, not that I'm aware of.
January 12th, 2025.
Not that I'm aware of.
Now, when you initiated your traffic lights, you stated that the bicycle continued to approximately one city block.
Yes, sir.
After that, what did you do or what happened?
After that, Officer Vermeulen was in the rear. I was in front of the individual. I exited my vehicle and observed the individual to still be straddling the bicycle, which again is one of the more common cues that he's not going to exit the bicycle and he's trying to decide whether he's going to run or he's going to comply. because it is dark. We have our emergency lights on. He is in dark clothing. And it's common for other vehicle traffic to be blinded by our lights. The last thing I wanted was the individual to flee, and the most likely direction would be into traffic. So for his safety and ours, we did not want to get into a foot chase, and I didn't want him to run into traffic. We detained him with handcuffs quickly. He was detained from the moment the lights came on. We just finalized it with handcuffs.
And after you detained him in handcuffs, what did you do?
After we detained him with handcuffs?
Yeah.
I explained the reason for the stop, both of the city ordinance violations, made sure he had a clear understanding of what we were doing and why we were there.
Before you explained the reason for the stop, did you take him off the bike?
Yes,
Did you relocate him?
yes, I relocated him to the front of Officer Vermeulen's vehicle for multiple reasons. One, it gives a barrier between him and traffic. Two, gives a table for us to place items on in case we're going to search. And three, there's multiple cameras, the dash camera, my camera, and my partner camera roll.
At this point, did you tell him that he was under arrest?
No, we told him that he's being detained for the traffic stop.
Did you ask him if he had anything in his pockets or anything on him?
Yes, we asked him if he had anything on him, any narcotics. The individual stated he had marijuana in his pocket.
And as a result of his admission, did you search him?
Yes, we searched incident to the known narcotics in his pocket.
What did you find, if any?
After that, we located a folded up piece of paper containing a crystal-like substance. It was loose, which is uncommon. It was not sealed up in a baggie. And prior to addressing the crystal-like substance, the individual stated multiple times that he was near a car wash and picked up the paper. After we stated that it looked like crystal meth, the individual stated it wasn't his and he didn't know what was inside of the paper.
I understand. I have a few more questions. The area in which you detain this person, can you give a general description of it? Is it a residential area, commercial, industrial?
Mostly a residential area.
Houses, apartments?
Yes, sir. There's, if I remember correctly, the sidewalk which he was on, he was opposing traffic, and there was a bike lane available. To our left was a residential area.
How would you
House.
describe, how would you describe the light in that area?
Not good. There's not adequate street lights. If we didn't have our emergency lights going and our headlights and any lights we had on our body, the individual would have been in relative darkness, especially to the untrained eye, the normal person in public, probably would have overlooked him, especially if he was in the roadway.
And how did you identify this? Did they present an ID? Did they identify themselves verbally?
He identified himself verbally, giving his name and date of birth.
And to the best of your recollection, what was that name?
Jack Evans. I don't recall the name.
Understood. My last question, when you see Mr. Evans, did you display any of the weapons which you are equipped, or any of the compliance measures that you have available?
No, we have firearms, firearms, we have tasers, and some officers carry a expandable baton. We displayed none of those and did not feel the need to go to any of those because we used empty open hand techniques to get him detained.
Okay, Judge, at this time, State Office Exhibit 1.
Any objection? And counsel, are you going to ask him questions as we watch State's Exhibit 1?
Your Honor, I think if the court would just like to view it, we could just view it and then subsequent to the viewing, I can ask him questions. It's very short.
All right, well, do you want to ask him questions and then
Sure.
I will view it and make a ruling on this?
Yes, Your Honor.
Probably tomorrow, because I'll need a chance to view it and we're in a jury trial.
Of course, no problem, Your Honor.
But however you all want to do it, if you all want to show it to him now, that can be shown to him now, if you want to ask him questions about this.
I'm agnostic.
Yes, Judge, I think that'd be fine if you can show it to him now, that way.
All right.
It is your-
Oh, thank you. All right, so you'll need to do it from their equipment and broadcast it. And I'll be able to watch it on the big screen. And then after this is concluded, I'll take up Rocha. And that's a motion for bond, and also Escobar, which is a plea. All right, thank you. Let's give this to you. I'm sorry. All right, thank you. Let me get that to you. Yeah, yeah. Okay. You're the expert at this, Megan.
Thank you.
Have you all started?
Yes,
Is there a sound?
there is eventually.
Okay. I'm sorry, could you rewind it to the beginning for me, State? Yes.
Really? You look back, you saw me. I didn't know this thing on the list. Wow. You had an over. Hey,
So, officer, do you recall this video that was from your body worn camera?
Yes.
Okay. Let me ask you some questions, sir. Is riding a bicycle on the sidewalk, a crime that is commonly associated with violence?
No, sir.
Okay. What about failing to have a light?
If you want to play.
What about failing to have a light on the front and rear of the bicycle? Is that commonly associated with violence?
Not in my experience.
Okay.
But let me caveat that. No, that is not commonly associated with violence. However,
Thank you.
it is commonly associated with people who would flee through a traffic stop. when they're pulled over.
Thank you for that response. Now you say that he failed to stop when you guys had initiated the lights first and foremost. Is that correct?
Yes.
Okay, where is that listed in your report? Can I have that report for you if you want to furnish, recall your memory?
Yeah, would you
like
take a
to-
look at this?
Yeah, yeah. If you
So
could just
this
please.
is not my report.
Okay.
The handling officer is Officer Brent Vermeulen.
Okay.
So I'm covering this, this.
Okay, did you do a report as well?
No.
Okay, you did not do a report
No,
with
sir.
regard to this. Okay.
Yes, sir.
So, information on here, if it didn't have where he had taken off or had to try to evade, that just didn't make it to the report. Is that what you're saying?
I didn't write this report.
Okay. When you approach and get out of the vehicle, is my client trying to evade or trying to get away from y'all in any way, shape, or form?
No, sir.
Okay. And you said you had additional officers with you, correct?
Yes, there's two of us there.
And to the best of your recollection, my client was alone, was he not?
Yes, sir.
Now, the way that you went about arresting him was quite quick, wouldn't you say?
Objection to the defense's characterization that this is an arrest.
All right, that'll be overruled. You can ask your question.
Placed in handcuffs.
I'm sorry, you're asking if it was quick?
Yes. Did you feel like a lot of time had elapsed between you getting out of the car and you handcuffing my client?
I feel like an individual was detained in a reasonable amount of time that was safe for both ends.
Did you feel that the amount of force was necessary?
Yes,
And why did you feel that amount of force was necessary?
the amount of force. The individual was removed from the bicycle. To the best of my belief and knowledge, he didn't incur any injuries. And he was placed in handcuffs.
Is that the way you go about doing investigative detention upon stopping people in the streets, is accosting and handcuffing them?
No, the individual accosted and handcuffs there. No, he was being stopped for a city ordinance violation, and based off of my experience, when they don't immediately exit the bicycle or come to a complete stop, oftentimes they're fleeing or they're considering fleeing. And it's a safety hazard for both us and them.
So going back to the city ordinance issue, when you see someone violating a city ordinance issue, say, for instance, jaywalking or maybe riding a bicycle on the sidewalk, do you cuff them and place them in custody and question them like that?
Objection relevant.
Overruled.
Say, for example, let me simplify it for you a little bit. If I was walking across the street and I jaywalk, say I don't wait for the crosswalk to happen. I mean, it occurs all the time right here on this four-way stop over here in front of the courthouse. If I go ahead and do that, are you gonna come up with me and you're gonna handcuff me and then go and ask me questions at that point and I'm already handcuffed? Or are you gonna talk to me real like as an actual person and try to delve and see what's going on?
It's all dealt with on a case-by-case basis. And you're indicating the area in front of the courthouse, which is not the area I work. I don't know anything about this area.
I'm saying hypothetically, yeah.
Hypothetically, I don't work this area and I don't know anything about it.
Okay.
So I work south and in that area, at the time of day, the location we were at, the area he was leaving, known for narcotics pickups and deals. His behavior, all of it added up to multi-factors to our actions.
So you said he was leaving a gas station, right?
He's leaving a gas station area.
Gas station in the area. So couldn't he have easily just been getting a soda or
Absolutely.
or some chips?
Absolutely.
And you're coupling that with the fact that he was on a bicycle to try to justify the fact that you just handcuffing him without doing any kind of questioning before that fact?
No, the reason that he's being handcuffed is, once again, the length of time it took for him to come to a stop after the emergency lights were activated and him not immediately exiting the bicycle.
And you heard in the video that he says he didn't really see you guys. Did you not? Like in the video, he says, I didn't even know what's going on. I didn't see you guys. Maybe possibly he doesn't see that point, because you're saying this happened, but where is that listed in your report?
Again, I didn't write a report.
So is it
The
typical?
handling officer wrote the
Is it
report.
typical for you to not write reports when you're going ahead and handcuffing people and asking them questions?
For cover officers, on most every call, no, they don't write reports.
But you're the one that actually handcuffed him, took him off his bike, put him against the car and started questioning him, correct?
I'm the one that first made contact with the individual, and both myself and Officer Brent Vermeulen detained him with handcuffs and then began questioning him.
So that gets me to another point. You relayed information to the other officer made a report stating all these facts. Is that what you're saying? Or you have no knowledge?
No, what I'm saying is that Officer Brent Vermeulen and I were both partnered up at that moment.
Okay.
And we both initiated a traffic stop together, which is common for officers around the city and other departments to take calls together, make traffic stops together. And at the time that we detained the individual, we started working it from there.
But you were the person that or the officer that got out of the car and then handcuffed, correct?
As it appears on the video, it looks like I made contact with him first, but Officer Brent Vermeulen was right behind me.
Okay. And who asked the questions of the defendants?
Both of us asked questions.
Okay. And you didn't feel like the need to do a report just to cover your basis in terms of the handcuffing and the questioning?
When it comes to traffic stops that result in an arrest, there's a handling officer and then there's cover officers outside of that. There's some cases in the department where a supplement report is required, and that's usually dictated by a supervisor. In this case, it's just a simple one officer is handling the report and the other officer is covered for safety.
Did you witness my client do a hand-to-hand with anybody?
Not that I remember, no, sir.
Did you witness him committing any other infraction besides having the city ordinance of having the bicycle on the sidewalk or not having the lights? Did you witness any other kind of criminal infractions?
None that are coming to mind right now.
So there were two of your officers and just my client, right?
Yes.
Couldn't you have requested that he get off of the bike? He gets off of the bike, you're questioning or he's questioning, and then the other officers maybe keeping an eye out for safety. I mean, couldn't that have happened instead of what happened on the video?
What happens commonly in the traffic stops is when we initiate our emergency lights. Most people in society have gone through some form of driving school, driver's ed when they're in high school. And it's covered in that program that people are to pull over when they're being stopped by the police. And when they don't do that, we at that point start to take guesses as to why. Either they're not seeing us, or they're refusing to pull over, or there's something inhibiting them from understanding the situation. There's all kinds of reasons why he might not pull over.
But again, as far as we can tell, since you didn't do a report, it's not documented on your end, and you don't know what the other officer documented on his end, do you?
The documentation on my end is on a video in front of us, both my body worn camera and then the video attached to my vehicle, and then the handling officer wrote a report.
Documentation usually refers to written correspondence rather than video, does it not?
There is video documentation and there is written documentation.
In this instance, there is no written documentation as to a report.
No, there's written documentation. It appears like it's right here.
That you wrote though.
No, sir.
And you're maintaining that type of force that you used was reasonably necessary to effectuate the goal of seeing why he was riding on the bike on the sidewalk, or that reason why he didn't have the lights on. Because did you charge him with evading on foot or evading on a bicycle? I'm just curious.
I'll go to your first question. Do I think the force was necessary to affect him being detained? Yes, and he was detained at the moment that the emergency lights came on, and we completed him being detained at the moment that the handcuffs were put on this person.
Would you agree that if a person is cuffed, and the situation went how it went by, where everything happens really fast, that objectively speaking, he may not have had the whereabouts of whether he could leave or not, or the know-with-all that he could leave, or the freedom to leave? Did you feel like you restricted his freedom?
I'm not understanding your question.
The way that the video is portrayed, where it just gets out, really no verbal dialogue, it's just taking and restraining the person. Could it be seen objectively that he didn't believe that he could leave at that point in time? Could he just walked away at that point in time after you cuffed him?
At the moment that the traffic stop was initiated, he was not free to leave. And most people, again, who have gone through some form of driver's ed understand that they're being detained at that point.
But I was asking about the moment when he was handcuffed.
The moment that he was handcuffed, yes.
Do you believe like he could
A reasonable person would believe that he was not free to leave at that point.
So he could have just taken off down the street, handcuffed and all?
Could he have done that?
Well, would you guys have allowed him to? If he didn't answer the questions to your liking, he said, no, I just want to go ahead
I
and
get
assert my constitutional rights to not speak to you. I want to go ahead and just walk down the street with, I mean, would you guys have been talking to him at that point, or would you guys have just continued the way that you guys had continued?
At the moment that the traffic stop was initiated, he was detained, and at that point, he was not free to go.
Okay.
If at any point during the stop he had left, no, he would have been free.
Yeah, so he probably couldn't have gone at that point. Did Mr. Evans, was he cooperative with you guys? Like when you guys were talking with him?
After we made physical contact with
Yeah.
Mr. Evans, he was very cooperative.
Did he submit to your show of authority?
I'm not understanding.
Did he submit to your show of authority, like you as the officers?
Can you define a show of authority?
You as the officers handcuffing him, placing him in custody, he didn't resist or anything like that, did he?
Did the individual resist after he was placed into cuffs? No, I don't remember him resisting after he was placed in cuffs.
And then the show of authority is more like he was following y'all's request and he was cuffed and he didn't really feel like he was free to leave at that point because you guys had him cuffed.
Based off of your description of a show of authority, and correct me if I'm misunderstanding, the show began at the moment that marked patrol vehicles with light bars affixed to the top of them, rolled up on them, and emergency lights were activated. And at that point, I wouldn't say he submitted to that show of authority, as I guess as you're defining it.
But in the video, you see you guys roll up and he doesn't try to take off on the bike, or he doesn't throw the bike down and run, does he?
No, thank goodness, no,
He's going
for
quite-
his safety and our thing.
He was going quite slowly, almost to a stop. Would you not agree?
After I got in front of him, again, I'm using approximation to approximately one city block. That he was being lit up, and it took I had to get in front of him for him to come to a complete stop at that point. Or I had to get ahead of him on the roadway for him to go to a complete stop.
Yeah, but when you did stop the vehicle and then see him and he's on his bike, pretty much stopped there. You all don't ask him any questions or anything, right? At that point, before handcuffing him.
Again, I gave a statement earlier, in my experience, when individuals in the setting that we're talking about, operating a bicycle, as we're describing, when they don't exit the bike immediately, oftentimes we have a situation that can become very unsafe for both the individual and for officers. And to mitigate that safety concern for him, for us, and also for anyone using the roadway, yes, he was placed in cuffs.
You say that oftentimes, but wouldn't you agree that every encounter is on a case-by-case basis?
Absolutely, but we also have to use our good judgment as officers to learn from prior history and to make good decisions for what we can do in the future based off of our own experience, which is why that comes.
And in this situation, did you see him doing anything threatening?
No, no.
Okay.
Other than, like I said before, he wasn't exiting the bicycle immediately, but the threatening, no.
But you can't see from your vehicle or the Biz video when he was kind of stopping, or when you're saying that you pulled up on him and he was kind of already on the bike, not able to make really an aggressive stance or aggressive movement towards y'all. Would that be fair to say? He was being compliant at that point.
If he was able to make an aggressive movement towards us?
Yeah, he wasn't, right?
I would disagree.
Okay.
Many people in a lot of aspects of my job are able to make quite aggressive and violent movements from seated positions, from lying positions, from standing positions, and from being straddled on a bicycle.
But in this situation, I mean, he didn't have a weapon. You didn't see him do any kind of illegal activity other than
No,
the
and
riding on the
I'm not
bicycle.
going to get into a situation where I try to make judgment calls based off of split-second observations. I'm going to try to make things as safe as possible for all
Right.
people I encounter.
With also maintaining that they have rights that need to be protected as well. You
Oh,
forgot that
absolutely.
part, or you were gonna add that?
No, his rights.
I was just checking. Because you had another officer with you, and my client was by himself on a bicycle. That's what it comes down to, right? So what was the time frame between you cuffing and handcuffing and taking Mr. Evans to the car and asking him questions? What was that time frame like? Was it a large amount of time? Was it a short amount of time?
As viewed on the videos, I would just describe it as a reasonable amount of time. To me, in my experience, this is, y'all use the word quick. I don't see this as quick. I just see this as a resolve.
As a result, do you think it could be resolved in another fashion?
It could be resolved in any fashion. Just based off of our own observations, what we have in front of us, and based off of his actions.
Right.
Based off other people's actions.
Or perhaps communicating with people before such action is taken of a coercive nature to handcuff someone and restrain them of their liberty. Communication could be key, correct?
Based off of the video that we all just watched and based off of my memory as well, I advised him to exit the bike multiple times prior to.
Okay, well, I must have not have seen that. Let me go ahead and replay the video. Continue playing the video. You said that you asked him multiple times to get off the bike before he got off?
Say, get off the bike, get off the bike.
Okay, did you allow him the time to get off the bike, or did you guys just swarm him? Okay, where did you allow him time to get off the bike? Is my question to you.
During the time that I was saying get off the bike.
Get off the bike as you were grabbing him, throwing him off the bike and handcuffing him. Is that what it was?
I don't remember throwing him off the bike, and I don't see throwing him off the bike.
Okay, well, you grabbed him, tear him off the bike. You could have asked him to step outside of the bike. Sir, you're aware that you're violating a city ordinance. Could you have gone about it that way?
There's many options on how we can detain somebody. Again, with what I had in front of me, based off of my experience, the last thing I want is for any person to flee from us until on a bicycle, and that can travel faster than foot speed for both me and my partner. And the last thing I want is for an individual to end up getting hit by a vehicle or to put themselves in a situation where they're going to get hurt or we're going to get hurt.
And you reference detention. Are you aware that if more force is necessary to effectuate the detention, it could turn into a custodial interrogation if questions are asked?
If more
force is necessary to maintain the status quo or to effectuate the reason for the stop, if more force is used more than that, then it could, you taking someone in custody or handcuffing someone could be viewed as the objective standard is taking someone into custody. Are you aware of that provision of the law?
Yes, and I don't think that more force than was necessary to affect the detaining and handcuffs was used here.
But that's your opinion, that's your subjective opinion, correct?
Sure, absolutely, yeah.
So once he was taken from the bike and handcuffed, you guys started asking him questions, did you not?
After the individual was placed in handcuffs, yes, he was asked questions.
Okay, did you read him his Miranda rights at that point in time?
Don't know how deep we got in the video. I don't remember reading his Miranda rights at that moment.
Do you know if the other officer read the Miranda rights? So you're not sure if Miranda rights were ever read in conjunction with the statements he made after he was placed in handcuffs?
Right, in conjunction, meaning like what do you say?
Like after he was placed in handcuffs and asked questions, you're not sure if he was Mirandized or not?
I'm not sure if Mr. Evans was Mirandized any point.
And again, that probably would be useful if there was a report written, but you're saying you never wrote a report, right? Just to clarify.
Again, the handling officer wrote the report, and whether he was Mirandized or not is on the handling officer. Because he's making the arrest on paper.
No further questions, Your Honor.
Right, state? Yes.
When you activated the emergency overhead lights on your patrol vehicle, did that indicate that you intended to detain a person?
Yes.
And so that is a show of authority.
Yes.
And did Mr. Evans respond to that show of authority?
Mr. Evans' response to the activation of lights was to keep rolling on his bicycle.
Any further questions? Any further questions?
None from the defense, Judge.
All right, is this witness excused?
By the state.
Yes, Your Honor, from the defense.
All right, thank you. All right, State, any further witnesses? Defense, any witnesses?
No witnesses, Judge, just justification.
All right, the court will hear a brief argument. State? I know it's defense's motion, but I'll have you proceed first.
The only comments that I really need to make are contained in Rhodes to the state, which is a decision by the Court of Criminal Appeals from 1997, which I can provide copies to the court of defense.
Okay.
But essentially, the Court of Criminal Appeals ruled that reasonableness under the Fourth Amendment, while not capable of precise definition, must be judged from the perspective of a reasonable officer at the scene rather than managed eyesight. And furthermore, allowances must be made for the fact that officers must often make quick decisions under tense, uncertain, and rapidly changing circumstances. Now, defense counsel asked quite a few questions about hypothetical situations in which Officer McFadden may find himself in other environments. But we're not talking about hypothetical situations in which he may find himself. We're talking about the actual situation in which he did find himself, the actual circumstances, the actual environment, the actual conduct of the defendant, none of which was rebutted by defense counsel. So considering the time of day, the area, Officer McFadden's personal experience on that patrol, the actions of the defendant in response to a show of authority, it is reasonable, it was reasonable for the officers to detain him in handcuffs, given the circumstances, and detaining him in handcuffs was a reasonable use of authority enforced at that time that did not rise to the level of an arrest for which Mr. Evans needed to have the custodial warnings recited to him before his statement, his inculpatory statement, would be admissible in use against him at further proceedings, and as a result of which evidence was discovered. That's all.
All right, defense.
Thank you, Your Honor. In relation to this matter, Judge, simply, he wasn't charged with anything else. He was not charged with resisting. He was not charged with evading. The reports don't even mention any of this. And he's trying to point to an officer, and the officer may have done it. The officer's not here, and this officer did not do a report. I do have a report here, and there's no mention of any kind of conciseness of why, what the basis was of them needing to handcuff him. They were two officers there, Judge. You saw my client was not making any further movements. He was not trying to take off on the bike. They grabbed him immediately, placed him into handcuffs. And in my opinion, that amounts to taking into custody because the officers went from 0 to 60 like in 3.2 seconds without the need and basis for. Miranda is there just to safeguard these things about coercive nature of police interactions and a person being informed of their rights before they can actually consent and agree to a search or agree to remain silent. My client was taken, pulled, thrown into the front of the car and was not admonished as to his right to an attorney, his right to remain silent. The officer says that he didn't believe that he could walk away. Being in custody is based upon numerous factors, is based upon the nature of the crime under investigation, which is for a ordinance of riding a bike on the sidewalk. This, in my opinion, was the officers targeting my client because they saw him as an easy target, a way to justify some stops, a way to justify some arrests. Also, the reaction of the suspect can also be determined as to when the officers roll up on him, he doesn't try to take off like I just stated. So there was really no need, in my opinion, for the officers to go about this the way that they did. They could have asked him, sir, please get off the bike. Do you know what I'm stopping you for? You're in violation of this ordinance. And then they could have gone about investigating if they believed that there was other drugs or if other things going on.
So your argument is, you're not arguing about the stop. You're arguing about the fact that you're arguing that he was in custody.
Yes, Judge. I'm arguing that he was under custodial interrogation. The officer, in my opinion, he did, albeit petty, a reason to stop my client in violation of an ordinance. So we're not attacking or we're not challenging the reasonable suspicion.
So you're saying that when he was, you're saying he was taken into custody, that he wasn't Mirandized. And during that time, is that when there was an admission of drug possession?
That is correct, Judge.
And so you're saying that the statement was not properly obtained and anything else that follows from there should be suppressed.
That's exactly right.
Okay.
Yes, and sorry for not clarifying that. First, it's just, we're contending that the force utilized exceeds the reasonable force necessary to effectuate the stop and to maintain the status quo. That's the way the courts have held, that it can be transformed based upon a totality of circumstances and objective nature about how things were done. And that the way that things were done, the abrasive nature of my client being taken off of the bike, handcuffed, and then questioned without being Mirandized, is a violation of his due process rights. That he was, because if he was made aware that, hey, okay, I'm actually cuffed, they're actually looking into me, I need to maybe keep my mouth shut, or maybe I need to have an attorney, he could have made that request, but that was not made available to him.
Okay.
And all this happened within a span of like 5-10 seconds, as you can see from the video.
Okay, then I understand both parties' arguments. State, I understand your argument. Defense, I understand your argument. What I will do is I'll review the video, and I'm familiar with both of the case law that you all have presented to the court with Rose and also with your case law, but I still like to reread case law, even though I'm familiar with it. So what I'll do is I'll have you all come back tomorrow.
Judge, I'm gonna be out on leave tomorrow,
All right, so when will you be back?
the 19th and after.
All right, so what I can do is, where are you gonna be tomorrow?
I'm gonna be out of state.
Okay, so what I can do, I can do one or two things. One, I can send you all an email with what my proposed ruling will be.
Okay.
That way both parties will know.
Yes, Judge.
And that way, if I were to rule in the defense's favor, which I'm not saying I will or I won't, then your client won't be held over if I were to rule in your
Oh,
favor.
great, yes, I'd be amenable to that email correspondence. It is.
You tell me tomorrow morning that you're going to rule in favor of defense counsel, I'll send a motion to dismiss.
Okay, all right, so and I'll send. All right, so I'll send you all an email to let you know.
Okay.
I just want to make sure I review the video, review each of your case law again, and then I'll let you all know what my decision is going to be.
I'd like a printed copy of the case.
Yes, thank you. And then Norma, if you can have Mr. Evans brought over tomorrow. And Mr. Evans, I'll let you know what the ruling is as well.
Can you excuse my language? They scared the hell out of me.
Oh, no.
Language
No.
is pretty
All right.
friendly.
So we'll recall it for tomorrow.
Thank you, Your Honor.
Thank you.
And,
You're a nice judge.
All right, thank you.
I'll be available, Judge, and should someone need to be here from my office to cover, I'll make those arrangements as well, whatever the court needs.
All right, so my understanding, we have a verdict in the case, so I'm going to do this plea very quickly, and then everyone else, after I give them the verdict, will bring your client back out. So who is here on Dominique Escobar? Court is calling 2025 CR 003779, State versus Dominique.